No list. Special weekly list, old matter, item number 1.
May I please, Your Lordship?
Yes.
In item 1, my Lordship, I am for the appellant. My Lordship, kindly see the office note in the cause list.
Yes.
For the service of notice and admission matter, for the following LRs, it has been completed, my Lordship. But subsequently, a fresh notice in admission issued to LR number 1A5 by registered post with AD returned unserved with postal endorsement, no such person in the address. Such notice to LR number 11B by registered post with return unserved with postal endorsement refused. Such notice issued to LR number 11E by registered post with AD returned unserved with postal endorsement, address is left. Such notice issued to LR number 15D by registered post with AD returned unserved with postal endorsement left. On other legal representative, my Lordship, the notice has been sufficient, but for these three, that is 1A5, 11E, and 1115D, Your Lordship, I have to take fresh notice by giving a fresh address, Your Lordship.
What is the matter, sir? This is a single judge's matter, judgment which has been challenged, correct?
My Lordship.
Let us hear you. Let's see if you want to go ahead with the matter or not.
Actually, my Lordship, Mr. Rautra will argue the matter.
We'll pass it over then. Ask him to come and argue.
Actually, my Lordship, I want to make a mention, Your Lordship. I have a small difficulty. Day before yesterday, I have welcomed a baby boy in our family, so I have not gone through the file, Your Lordship.
So it's a 1994 case, sir. Please.
Can you take it up next
Why
week,
should
Your
we
Lordship?
adjourn 1994 case, sir?
Let me stay on board, Your Lordship. I'll pay Friday or
There's no staying on board. This is an old weekly list. You know, we bring out these lists long ago.
usually I don't ask for
The
adjournment,
senior
Your
Mr. Rautra is to argue, correct?
My Lordship.
So let him come and argue. You carry on.
Can I take it up tomorrow, Your Lordship?
No, Mr. Rautra, if he's asked to argue, let him argue, na?
Even he is in difficulty, Your Lordship. He is not there. So can I pick it up on next week? On the Monday, Your Lordship. Or any day, Your Lordship, please. Yes.
Or we'll
this
just reserve orders, you file your written notes of argument. I think that's simple.
Then I should pass
We'll
it.
reserve orders. You file your written notes of argument.
Then I should pass it over, my Lordship. I will call Mr. Rautra.
Special weekly list, old matter, item number 2.
May it be. But here I prepared one written submission. Lordship, may kindly have a glance. 2-3 dates are important for the purpose of the case. Here, my lord, I am challenging the order of the divisional court passed by the opposite party number 3, given in annexure 3. Lordship, I have given the genealogy, one genealogy in my written note of submission. As a Lordship,
Yes.
yes, in page 1, the Bornamali Mishra is the real owner of the property. Thereafter, the land has come to the hand of Harihara, and thereafter his son Bhagavan, and Bhagavan has two sons, Ramachandra and Narayana. Or Ramachandra is the opposite party number 4, and Narayana the petitioner before Your Lordship. What happened, Your Lordship? In the year finally published consolation error, it has been recorded in the name of Narayana, Ramachandra, and Ramachandra made an application to the OEA collector, the Tahsildar Nimapada, to record his land exclusively. Thereafter, the present petitioner also made an application which was for recording of the land jointly, and it has been on dated 13/3/1980. See page 2. Page 2 I am referring. 13/3/1980. Ramachandra opposite partner 4 applied for the settlement of the entire land in his favor, and which is registered as OEA lease miscase number 150/1980. And thereafter on 8/4/1980, the present petitioner has filed a OEA miscase which is registered at 285/80 for settlement of the 50% of the land. And by common order dated 6/11/2018, had both the parties, and the order has been passed directing to record in the name of both. Thereafter, the present opposite party number 4, the present opposite party number 4 preferred appeal, which was confirmed under annexure 2, Your Lordship. Thereafter, he preferred revision before the ADM, and the ADM had set aside and remanded the matter within some specific allegations. Admittedly, Your Lordship will find I have given by way of rejoinder annexure 4, which was recorded in the name of Harihara.
Yes.
By operation of law, it is entitled by both the parties.
All right.
But it has been recorded only in the name of so consolidation record of right. It has been recorded in the name of Ramachandra.
All right.
My submission is it has Annex 3 is to be set aside, and it has, in view of the successions operation of law, it should have been recorded in both the.
All right. All right.
Yes,
All
sir.
right. What was there a stay order here, sir?
Yes, Your Lordship. 9/11/1995.
All right. Yes, who's for the other
You
side?
see, I am for the remand order is under challenge.
Right.
So it is not finally decided.
Correct.
So let it be adjudicated by the lower authority. And
Correct.
if at all it is again forum is available to him to challenge
You
that.
can always challenge it.
Lordship, may kindly see that remand order. They have specifically directed on in view of the Lordship for a moment. Page 42, Your Lordship.
Yes.
In conclusion, as all these appeals appear to have not been looked after carefully, the same is remanded to the court of Tahsildar Nimapada for disposal according to the law after complying the point discussed above. Well, let it be open remand. I may be permitted to place my case.
Yes,
In
yes.
both the courts, I have doubt.
All right.
Yes,
It's open
that
demand.
can-
What
that
else
can-
it is?
Yeah.
You have said in the light of the discussion.
Right. By the
Authorized
impugned order,
that
the appellate court has remanded the matter to the Tahsildar for a fresh decision. The only apprehension expressed by the counsel of the petitioner is that the petitioner's points of view may not be considered by the Tahsildar. There is no room for such apprehension. Once a matter is remanded, both sides, all parties are obviously permitted to place all their points of view before the Tahsildar in accordance with law. With the above clarification, the writ petition is disposed of. The interim order stands vacated.
Not revisional court. The remand has been made by revisional court.
All right.
yes.
Yes, sir.
The appellate court is a revisional court.
Special weekly list item number 3.
Lord,
None
item
appears.
3, my lord. I am for the opposite party, my lord.
All right.
Oh.
None appears, dismissed or non-prosecution. All right.
My lord, my name may be recorded. My lord, S.C. Das, my lord, for the opposite party.
All right, sir.
Special weekly item number 4.
None appears, dismissed or non-prosecution.
Lord, in item 4, I am on behalf of the opposite party number 7, my lord.
All right, sir. All
And
right.
it is a case covered under
Sir,
Annex
we are dismissing it for non-prosecution. All right.
my lord.
Special weekly list item number 5.
None appears, dismissed or
My
non.
lord, I am for the opposite party.
All right. Come on. Yes, sir. Please tell us.
My lord?
It was opposite.
Kind. You are for the opposite party.
Yes, my lord.
All right. Dismissed for non-prosecution.
Special weekly list
The
item
stay
number
may
6.
vacate. Interim grant to stay.
Item number 6.
Item 6, my lord, on behalf of Mr. Mishra, A.K. Mishra is for the petitioner. His mother expired, I pray 10 days time.
When did she expire, sir?
On last 6 days ago. He is in village for his rituals.
What is the matter about? Let us see that.
I have no power and file also.
Let us see. We'll see it ourselves. Selection list of 97 in the post of inspector.
Selection of the year 97 is under challenge. ma'am.
Yes, yes. You see, this petition challenges the selection of the year 1997. That is more than 25 years ago. The court sees no reason why, at this stage in time, it should interfere with such election. The petition is dismissed.
Special weekly item number 7.
None appears, dismissed, and non-prosecution.
Special weekly item number 8.
None appears, dismissed, and non-prosecution.
Special weekly list item number 9.
May I please, your lordship? Yes, this petition has been filed. And the impugned order is at annexure 1. During pendency of the writ petition, the opposite party has expired. And IA number 1815 of 2018.
Mr. Mudli, you have to speak into the mic. You're not audible at all.
And the impugned order is at annexure 1, setting aside the order of dismissal by the land tribunal. And here, during pendency of the writ petition, the applicant has expired. And the legal heirs of the applicant have filed.
Why? What is the matter about you? Tell us.
The matter relates to dismissal from service after the applicant, who was a sub-inspector of police during his entire service career, he got 9 black marks, as a result of which a proceeding was drawn up and he was dismissed from service. That was challenged before the land tribunal, and in the impugned order, the land tribunal has been pleased to set aside the order of dismissal solely on the ground that the DIG range, who has passed the order of dismissal, that he is not competent under the police manual rules to dismiss the applicant. This order is completely.
So now this order was stayed by this court for the last 20 years. It has been stayed.
Yes, ma'am.
What will happen if the order stays vacated, the matter is dismissed? What will happen?
Well, he will be reinstated in service.
Now, please.
No, now.
Mr. Mudali, please answer with seriousness. This petition will be restarted.
No, now the consequence order.
Nothing. He won't get any reinstatement because of passage of time. What is his age, sir?
He is already expired, my lord.
Expired. That's the end of the matter, sir. The respondent is already expired during the pendency of the present petition. There is already a stay order by this court. There is already an interim order by this court staying the operation of the impugned order of the OAT, dated 19th May 2002, by which the respondent was to be reinstated. Since that order can never be given effect to now, the question of continuing to entertain the present petition does not arise. The petition is disposed of.
Specifically, item number 10. Item number 10.
10 no instruction, my lord.
All right. Counsel petitioner has no instructions.
Specifically, item number 11.
Item 11 has been filed by the state. The Lordship may kindly straightway turn to the impugned order. The amount
Minimum
involved,
Wages Act.
yes, the amount involved is only 36,000, running by 17.
We'll keep the question of law open, sir.
Yes.
The amount involved in the present petition, which challenges an order passed by the authority under the Minimum Wages Act, is insubstantial. Consequently, this court is not inclined to interfere. The petition is dismissed. Interim order stands vacated.
Yeah, not to be treated as a precedent.
All right. The impugned order shall not be treated as a precedent.
Specifically, item number 12.
My lord, the item has become infructuous.
All right. Petition has become infructuous. Disposed of as such.
Specifically, item number 13.
May I please, your lordship? And during the pendency of this petition, my lord, the petition has been expired.
All right. Counsel, the petitioner says this petition has been rendered infructuous. Disposed of as such.
Specifically, item number 14.
May it please your lordships. Lord, this matter, an assessment was made. Lords, your lordships take the second item, 5222.
All right.
Lords, an assessment was made under the Orissa Sales Tax Act. I challenged in first appeal. First appeal was rejected. I challenged the second appeal. Second appeal was allowed in my favor, directing the assessing authority to recompute my tax demand. It was not a reassessment. Then I applied for refund. The refund was granted to me. Lord, the interest was not granted. I am a public sector. I have paid the money from my own coffers.
What is the interest amount involved, sir?
My lords,
what is the interest amount involved?
my lord, the statute, my lord, the interest amount would be roughly about a huge amount. Reason is, my lords, I'll just explain, my lords. The statutory rate of interest was 18% and 24%, but it was from the date of the refund application. Refund application would be filed after the reassessment order is passed, not before that, but the refund is due. My claim before your lordships was that I intended interest from the date of deposit. This matter was referred to the full bench. And the full bench passed an order, which is there. I have quoted that.
I have submitted that judgment.
My lords, page 11 of the writ petition.
Sure.
This is covered by that judgment.
My lords, page 11 of the writ petition 5222 of 2004. Have your lordships got it? Lords, the last para, page para 94, subpara 6.
Yes.
Lords, when a dealer is directed to deposit some amount as per the orders of the High Court and the Supreme Court, he is entitled to get compensation by way of interest on the amount of refund ultimately calculated from such date at such rate as is directed by the said courts. Lords, in my case, when the court directed for payment, no interest was allowed. No interest order was passed. I have come up before Lordships claiming interest from the date of deposit because the state admitted
Your
has
Lordship,
used my money.
Your Lordship, in both the cases, Your Lordship may kindly turn to the prayer of the petitions. This prayer has been considered by tax at the same rate at which state collect interest on delayed payment of tax, the interest to be calculated from the date of deposit of the tax amount. And the second prayer is issue an appropriate writ, direction or order quashing subsection 1 of section 114C of the Orissa Sales Tax Act as amended, so and so, so and so.
He's only pressing the first prayer. He wants interest from the date of deposit.
Your Lordship, this issue has been considered by this honorable court. Your Lordship may kindly turn to that judgment, page 573,
Yes.
1.573.
Yes.
Your Lordship, thus both the prayers the issues have been adjudicated here. In OJC number 12,085, 12,087, 98, the petitioner has paid for declaration that he is entitled to interest refundable amount. So from the deposit till the date of payment, a prayer has also been made to pass the second proviso 1414C. Both the cases are referred to the division bench to be heard by full bench. Second prayer, the tax order of application, Your Lordship, section 14C. As per section 14C, Your Lordship, section 14C says that 90 days time has been granted to the assessing officer to grant the refund. If that has not been granted within the 90 days, from 91st day, the interest will be given to the dealer.
But all that is crossed, sir, once you've come to the court and you're asking for refund. What the assessing officer should have done is some long ago. So you can't again get another 90 days.
Your Lordship, that's right, Your Lordship. But section 14C has been declared as intervention.
So what? The short question is, from which date should he get interest?
Your Lordship, may kindly turn to section 14C.
Right.
Your Lordship, Section 14C1 says that, which has been prayed to be quashed by the petitioner.
He's relying on the full bench, the same full bench which you are relying
Your
on.
Lordship, Your Lordship.
No point going back to 14C. Under this full
Your
bench
Lordship,
judgment,
Your
the
Lordship,
court
Your
will
Lordship,
fix the
my
date. The court will fix the date under the judgment. The court will fix the date and the rate.
Your Lordship may direct as per the full bench judgment.
We again going in circles then, sir. Full bench judgment requires the court to fix the date.
Your Lordship, but that cannot be granted from the date of deposit. Your
Why
Lordship, my
not?
respectful submission.
Why not? Why not?
Your Lordship, because there are several, Your Lordship, a Tata refractory case, Honorable Supreme Court clearly says that, but when there is no direction, Your Lordship, interest cannot be granted. Your Lordship, but in this case also, my Lawrence Senior has enforced Tata refractory judgment. Your Lordship, in the past case, Your Lordship may kindly turn to.
Lordships can kindly turn to page 35 of the petition matters. 5222 of 2004.
Your Lordship, page 25.
Page 35. There's a judgment of the Honorable Supreme Court in the case of an Orissa matter where the Lordships have directed 9% interest from the date of deposit. Lords, page 35 of the writ petition, the last portion, my lords. That being so, on the peculiar circumstances of the case, grant of interest at the rate of 9% would be appropriate, my lords.
Anyway, today's day and age, 6% is also enough, sir.
My lords, and this honorable court had granted 8% as per the fixed
Your
deposit
Lordship,
rate of
Your Lordship, my respectful submission, Your Lordship, once the rule has been declared as intravirus, Your Lordship, that may not be granted from the date of deposit because there are several deposits. Your Lordship, and the rule as well as all these judgments clearly says that as per the statute, Your Lordship. And Your Lordship, until unless a favorable order has been come, Your Lordship, the refund cannot be granted. In these cases, first there was an assessment, and in the assessment there was a demand. And subsequently, in the subsequent proceeding, the demand has been declared as nil and refund has been thrown from the subsequent order.
Refund presumes that you should not have collected the tax right in the beginning. From the day which he parted with his money, he should not have parted with his money. So logically, interest is to be from the date he parted with the money.
There are different
This doesn't
payments.
require a great analysis.
Your Lordship, we have already.
Once the section has been held intravirus, once the judge, full bench says it's for the court to direct from which date he should get, you leave it to the court. That's the whole point.
Your Lordship may kindly turn to page 25.
All right.
Of the past case, where Tata refractory case has been analyzed by Honorable Supreme Court.
All right.
Your Lordship, as was observed by this court in Tata refractory versus State of Orissa in 2003, 1 SCC 65. It is to be noted that the order of the High Court in the earlier writ petition, namely so-and-so, High Court in the exercise of its power 226 and 227 of the Constitution of India, wherein while directing the appellant to deposit the amount quantified therein, the High Court also issued a direction to the respondent state that it should be refunded the amount with interest at the rate of 18% in the event appellant succeeding in the second appeal. This order is definitely not one made under the provision of the Act. The respondent state which took benefit of the said order and retained the amount deposited by the appellant cannot now be permitted to any direction made while making an order under Article 226 or 226 to deposit any sum of money will be governed by the condition imposed in the order directing such deposit. On the contrary, if any such condition as to pay the interest had not been made by has considered this case.
We are just simply giving effect to it, please. Let's
Your
not
Lordship.
go behind the full bench.
Your Lordship, Your Lordship, Your Lordship.
You see, these two petitions have been again listed before this court only as a fallout of the full bench decision of this court in Ideal Industries Limited, this is the State of Orissa, 2004 134 STC 62 bracket Orissa. Full stop. Paragraph, the question before the full bench concerned the payment of interest under section 14 capital C of the Orissa Sales Tax Act. On the amount refunded. Paragraph. The full bench answered the questions referred to it in para 68 of the judgment. Full stop. Immediately relevant for the present purposes is the direction contained in para 68 bracket 6, which reads as under A to A. Paragraph. Learned senior counsel for the petitioner has placed reliance on the judgment in Tata Refractories Limited versus Sales Tax Officer 2003 1 SEC 65 and urges that the interest should begin to run from the date of the deposit. Paragraph. Mr. Sunil Mishra, learned standing counsel, however, resists the above submission. Granting interest from the date of assessment was recalled by this court subsequently by an order dated 24/12/2019. Paragraph. Be that as it may, the question is only this: what should be the date from which interest on the refund amount should become payable? Question mark. The incidental question is, at what rate should such interest be paid? Paragraph. From the point of view of the SSC, since this is a question of interest on refund, it is clear that if the SSC is entitled to refund, the interest should begin to run from the date on which the SSC parted with the money in the first instance. Full stop. The refund itself is as a result of a finding that the tax ought not to have been collected from the SSC in the first place. Full stop. If the tax has to be refunded, clearly, therefore, in the considered view of the court, the interest thereon should begin to run from the date of the deposit of such tax. Full stop. Consequently, the issue is answered as under, in both these cases, as under, the department will pay to each of the SSCs simple interest at 6% per annum on the amount of refund from the period beginning with the date of making of payment of such interest in the first payment of the sales tax in the first instance till the date of actual payment, which should not be more than 8 weeks from today. If there is any further delay than the above period in making the refund, the department will be liable to pay simple interest at 9% per annum on the said sum for the period of delay. The petitions are disposed of in the above terms. So tomorrow, I think all those petitions can be disposed of in terms of this order. All right.
Special list item number 15. Item number 15.
None appears dismissed and not. Both matters.
Special list item number 16.
Because in this case, the petitioner challenge pillars annexure 3 and 5 pillars. Because annexure 3 is the pillars demand of tax and 5 is the pillars revision order. So also we kindly turn to page 27 pillars.
Right.
Page 27, the lordship will find that in connection with registration, they wanted to recover this amount. That period involved in 97-98, OST 95-686, CST 283-078. Plus, do these two matters pillars for recovery of demand in a collateral proceeding before your lordship in WPC 14501 of 2005, pertaining to OST and WPC 14502 of 2005 particular CST has been disposed of by your lordship along with one more application. I am giving a memo. The order passed by your lordship mirrors. The matter case was filed in those cases 2005 mirrors. Your lordship passed the order in 2013 because for 13 long period no counter was filed. Your lordship only on the ground that counter not filed, your lordship kindly see. In spite of order dated 4th December 2018 granting time to file counter, no counter is forthcoming. Only on the ground of non-filing of counter, the writ petition reserved to be allowed. Accordingly, the same are allowed. It is very clear that we have not expressed the opinion on merit of the case. However, state may prefer review of this order within a period of 30 days from today. That is order before 18 January 2009, along with the counter affidavit, failing which even the review application will not be considered. This type of order is being passed because of sheer negligence on the government officers. So, Lordship, may kindly see, I have filed along with this memo, the High Court website reports pillars. The review I find was filed on 21/1/2009, later than this order which you also directed. So,
what happened to that review?
Because that review is pending, but review state has filed, they have also not pursued for last 4 years. And that review is filed also beyond the time limit which your lordship had directed in this order.
Yes, Mr. Mishra.
This is
nothing to say.
Within my knowledge. Let me.
So here what happens, this repetition has to be allowed.
And so revision order, so far revision is concerned, Milos, against the demand of this 378 Milos, for grant of registration, I have filed a revision. My Annexure 5 it was disposed of. And Annexure 5 also, your lordship may kindly see, page 40, the only challenge is page 40, internal page 2. The petitioner challenged the above order in this revision petition on the ground that the impugned tax under OST sales tax amount to 3,78,764 of Snehadhara Industries is not the liability of the present petitioner. Requested this forum to direct the aforesaid sales tax authority to grant certificate registration. The remand was in the name of S12 minutes dealer. Now your lordship may kindly see the operative portion order, paragraph 8 at page 44 minutes. The petitioner has applied for provisional registration 9C of the West Tax and intention to establish a business in the state of Orissa for the purpose of manufacturing and producing goods. This order doesn't exonerate him from the area of tax liability of the erstwhile Snehadhara Industries. The Lord Sales Tax Officer shall take suitable action to recover the area from the erstwhile Snehadhara Industries Limited. From him, he will recover. The petitioner has disclosed the landed property of erstwhile Snehadhara in para 5.2 in the revision petition. Simultaneously, he should gather evidence regarding transfer of business in entirety to fashion liability of the petitioner. This will take some time. Grant of registration of particularly in this case cannot wait till that such time. 6 months time is reasonable. So in spite of the fact that 6 months was allowed way back in 2003 to investigate, because the provision under section 19 says of the OST Act, if the business is entirely transferred mirrors, then both the transferor and transferee both can be proceeded for recovery. So, my case all through was that there is no entire transfer of business in terms of section 19. I have relied upon 2 judgments of our High Court that are also referred to in this order. Despite of all this, quoting all this, revision authority says, all right, you conduct investigation. If within 6 months' time will be reasonable, and after 2003, 6 months elapsed, nothing has been done. And these 2 orders passed by Lordship,
Your Lordship, in this case, we have filed counter. So that order where we have not filed counter and your lordship has passed the order, that may not be considered in this case. And in this case, your lordship may kindly consider on merit.
No, this investigation was never completed, Mr. Mishra. This investigation, in terms of the revisional order, was never completed.
That investigation.
There's no stay of that order.
No.
In fact, if you read the earlier order of this court, 30th June 2006.
Your Lordship, we have issued the notice dated 2nd September 2003.
No. I want you to read the 30th June 2006 order passed in this petition by this court. You have that order? 30th June order. Just take the paper book. Show it to you.
No, Your Lordship.
No, 1 minute. We'll just show it to you, sir. It has worked itself out, sir. Nothing survives now. You did not conduct that investigation.
Your Lordship is absolutely right, but the revision at page 44 of the revisional order.
Yes. Para 8.
The petitioner has applied for provisional certificate under section 9C and with an intention to establish the business in the state of Orissa for the purpose of manufacturing, but this order does not exonerate him from the area tax liability of the erstwhile Snehadhara Industries Limited. The Lawrence shall take suitable action to recover the areas from erstwhile Snehadhara Industries Limited. The petitioner has disclosed the Lawrence property erstwhile Snehadhara Industry in para file. Simultaneously, he should gather evidence regarding transfer of business of entirety to first and
So
liability.
this was made conditional for enforcing the demand. If the business has not been transferred in its entirety, you can't ask for this amount to be paid. So this is a liability of the erstwhile industry. So without this investigation, the demand could not be sustained. So the provisional authority said to first make this investigation. All right.
My
This is
lord,
the challenge
as per the judgment of this honorable court and as well as honorable Supreme Court, your lordship, I can understand. But the past charge.
No, factually. See, factually, if there is no transfer of liability, how do you maintain the demand against the present petitioner?
Correct. But this is regarding grant of certificate. This investigation
So
is
that is preconditional for enforcing the demand, sir.
yeah, your lordship, in this paragraph 8.
Yes.
Your lordship, two parts. One part is recovery, another part is so far as the grant of registration certificate.
No, that's right. He's on this enforcing the demand, sir. That is why he's before the court.
My lord, your lordship, if the inter liability has been transferred, your lordship.
So that's why you are given 6 months to find that out.
On the face of record, it has been transferred. That entire asset and liability have been transferred.
The subject matter of the present proceedings is a challenge to a demand raised against the present petitioner by the sales tax authorities, exercising powers under section 9 capital C. No, what is this provision under which the section 7 bracket 1, no, 9 bracket capital C of the Orissa Sales Tax
7
Act
of the CST Act
and section 7 bracket 1 of the Central Sales Tax Act, which was in fact the liability of the erstwhile industry, Messrs.
Snehadhara Industries.
Snehadhara Industries Limited, bracket SIL, which was taken over by the present SCC, present petitioner, paragraph. In the impugned order dated 27th October 2003, passed by the Commissioner of Commercial Taxes, in the petitioner's revision case, PC-250/2003-04, it has been observed that the prerequisite for fastening liability of the transferor company to the transferee company, as far as sales tax dues is concerned, is determining whether in fact there is a complete transfer of all liabilities of the transferor entity. For this purpose, in para 8 of the impugned order, a direction had been issued to the department to, open quotation, gather evidence regarding transfer of business in entirety to fasten the liability on the petitioner, unquote. 6 months' time was granted to the department for that purpose. Paragraph. While the present petition was pending, this court had, by an order dated 30 June 2006, recorded the submission of counsel for the revenue that he is not in a position to inform the court whether the said investigation has been completed or not. Full stop. 3 weeks' time was sought and granted for that purpose. Paragraph. Those 3 weeks have long since expired. In the past 18 years during the pendency of the present petition, it appears that no investigation was in fact undertaken to determine whether the entire liabilities of SIL got transferred to the present petitioner. as a result of the takeover. Paragraph. Without that basic fact being established, the demand raised against the present petitioner for the amount due to the department by the erstwhile SIL, that is the transferor company, cannot be sustained in law. Paragraph. On that short ground, the impugned demand raised in Annexure 3,
3 and 5 years.
dated 27th September 2003, and to the extent it has been sustained in the order dated 27th October 2003 of the Commissioner, is hereby set aside. The petition is disposed of in the above terms.
Special weekly list item number 17.
17 minutes. This is data bill 16 by 2004, my lord.
You have to speak in the mic, sir.
Yes, ma'am.
We have 16 of 2005.
Yes. And 17 of 2005, that is fixed to 22nd, my lord.
That's
Same,
okay.
same nature of case. Same. My lord.
Right. We'll decide it here today. That will
Yes,
get decided as per
Yes.
today's decision.
Well, in this case, they have not.
Single
filed-
judge, you have challenged a single judge's order.
Yes, ma'am.
What has he asked you to do?
Honorable single judge has denied my claim. This is regarding the entitlement of benefit under pension. The applicants before the presiding officer labor court, my lord, were the descendants, wife, both of them are white. And much prior to the so-called cutoff date, 1490, the applicants, they have died. Much before, my lord. That is admitted fact, my lord. My question is, my lord, I have raised the question here in this case, my lord, that Honorable single judge at page 9, my lord, perusal of the decision, the para 12, my lord, they have not filed the counter in this case, my lord. Perusal of the decision thus clearly reveals that this court held unambiguously that the said petitioner, having retired prior to 1490, could not claim pensionary benefits. Judicial discipline and propriety demands that a bench consists of a single judge should follow the decision of a division bench, and more so when there is no divergent or contradictory decisions. While deciding the issue, a bench consisting of a single judge cannot doubt the correctness of a decision arrived at by a larger bench. The decision of a larger bench binds a single judge of the same court, and the judicial discipline obliges the single bench to follow it regardless of any doubt about its correctness. The only situation where a single judge can refer matter directly to a full bench is there being earlier conflicting judgments, and or when the bench comes to a conclusion that a judgment is so incorrect that in no circumstances can it be followed. I don't challenge this proposition. I cannot, my lord. But so far as the present claim application is concerned, under the regulation of the then OACB, now OACB is not here, that is under, they have filed the.
There is a cutoff date, sir, for pension.
No, my lord. Yes, that is Annexure 6, page 42. Here, clause 3 is the benefits under these regulations shall be allowed to all the regular employees of the board with effect from 1490. Honorable single judge has held that this is the cutoff date. My humble submission before my lords is this cannot be the cutoff date. And the honorable judge has relied upon a decision of this honorable court, division bench decision, wherein they have said that this is the cutoff date. My humble submission is, my lord, this is the very name, Orissa State Electricity Board Employees Pension, including old age and family pension regulation 1992. Here they say the benefits under these regulations shall be allowed to all the regular employees of the board with effect from 1490. My lord, thereafter they have written, provided that the period of service rendered by the regular employees in the workers' establishment count towards pensionary benefit if such employment win or are brought a minimum period of 5 years of continuous service is the worker's establishment, provided further that the following periods of service rendered by such employees shall not count towards qualifying service for pension. But a person, my ground, my lord, I have written in my writ application, my lord, at page 10, my lord, I am not going to the details, my lord. What I humbly submit at page 13, my lord, page 13, my lord, yes. Second para. In view of the statutory provisions aforesaid, the concept of cut-off date is inapplicable. There is no provision in regulation quoted above that the pension scheme will be applicable to persons who retire before or after 1490. It is submitted most humbly that the finding of Honorable Judge is contrary to the legal provisions which is apparent on the face of record, as the concept of cut-off date does not apply to the facts and circumstances of this case, my lord. Thereafter, my lord, para ground number 2 is, my lord, I have taken only 4 grounds, my lord. For that most important aspect of the matter which has not been taken into consideration by the Honorable Judge is that as the regulation expresses so that the regulations applies to old age and family pension, as such the concept that persons who are not in employment on or after 1490 only would be entitled under regulation 3 and 4 and none else is not correct. It is well-known concept in the law that a person goes out of employment only on retirement or resignation. In this case, though the deceased husband of the appellant have died much before 1490, that is admitted fact, my lord. But there being no cut-off date, that is to say, there being no date relatable to retirement, the provisions of regulation will apply with full force to this case of the appellant. My lord, they have said in the regulation, they have stated that benefits will be given. Now, my lord, the concept is proper interpretation of the words benefits under regulations shall be available to all regular employees of the board with effect from 1490 makes it clear that it has no relationship whatsoever to any specific date from which such benefits will be available. As the appellant's husband was an employee in a regular establishment and was a regular employee, clause 3 and 4 will be applicable to her not only for pensionary benefits, but also for old age and family pension. This is the second ground, my lord. And third ground is at page 14, my lord. My lord, may I kindly turn. Page 14.
Yes.
Humbly submitted, most humbly, that the earlier decisions of this honorable court, I have tried to make out my case, my lord, completely missed the point on the issue of existence and non-existence of a cut-off date. There it is written, my lord, benefits will be available. That cannot be construed as a cut-off date. The person is to still survive in the office so that he is entitled to get pension, my lord. On the issue of existence and non-existence of a cut-off date, it is submitted most humbly that when the question of old age and family pension is also governed by this resolution and the expression used in paragraph 3 that all the benefits under this regulation shall be available to all regular employees of the board with effect from 1490, it is clear that the expression regular employees of the board would also include the dependents and widow of the deceased employee who died prior to 1490. Reasonable interpretation of this regulation would be that widow of the deceased employees also will be entitled to family pension. In other words, the concept of grant of family pension makes it clear that surviving widow or other dependents would get the benefit if he or she would be alive on or after 1490. In this view of the matter, the Honorable Judge has committed grave error of law, which is apparent on the face of the record, by applying a concept of cut-off date and misinterpreting the word regular employee and also the basic structure of the regulation that it also applies to family pension. And my lord, thereafter, I have taken the help of that famous case of 1983 Nakara case, my lord. If I'm entitled to get pension, there cannot be divergent views. There cannot be two classes. So far as pensioners are concerned. If my lord wants, I can. Nakara case is a famous case. Can I be permitted to place only?
All right.
That is 83 Supreme Court 130. While the expanding horizons of, I am pressing the placitum only. I am not pressing the whole judgment. While the expand here, my lord, there were, as my lord must be knowing, central government pension scheme was in challenge, where the view of this Honorable Supreme Court is this: with the expanding horizons of socio-economic justice, the socialist republic and welfare state, which the country endeavors to set up, and the fact that the old men who retired when emoluments were comparatively low are exposed to vagaries of continuously rising prices, the falling values of the rupees consequent upon inflationary inputs, by introducing an arbitrary eligibility criteria, being in service and retiring subsequent to the specified date. That is under question, madam. For being eligible for the liberalized pension scheme and thereby dividing a homogeneous class, the classification being not based on any discernible rational principle and being wholly unrelated to the objects sought to be achieved by grant of liberalized pension, and the eligibility criteria devised being thoroughly arbitrary, the eligibility for liberalized pension scheme of being in service on the specified date, here that is 1490, and retiring subsequent to that date in the memoranda violates Article 14 and is unconstitutional and liable to be struck down. But as the arbitrary and discriminatory portions in the memoranda can be easily severed, both the memoranda shall be enforced and thereafter number of objections.
All right.
My
That's
lord,
it, sir.
my lord, in this case, my lord, I have instructed for the on behalf of the opposite party to appear. Let the petitioner be directed to serve the copy of the.
No. We are not inclined to entertain the petition at all, sir. All right. The appeal is dismissed. We'll pass the detailed order.
Special weekly list item number 18.
Data appeal number 17 of 2005, 2006, 2000.
You can take it on board today. It will be dismissed in view of this dismissal.
That is on 22nd. It's ordered to be listed on 22nd, madam.
No. If it is covered by the same order, then same taken on board and both are
My
dismissed.
lord, may I be permitted to give a short?
The next day in 2017 of 2005 is cancelled. You give a note by today evening. You have to give it, sir.
Today evening?
Yes.
What about tomorrow?
No. Yes.
Special weekly list item number 18.
None appears dismissed. No.
Special weekly list item number 19.
None appears dismissed. No.
Special weekly list item number 20.
My lords, here the file has been transferred from the chambers of SP Mishra.
All right.
The name may be deleted from the cause list.
All right.
I'm
the opposite party now in item 20.
I'm in a predicament, my lords. I'm suffering from throat fever, my lords, for 3-4 days, my lords. Completely sore throat. Can be accommodated. I know that it is a
answer. You are for the petitioner now.
I'm the petitioner, my lords.
All right.
But in this case, I may be permitted to
next week.
Parties to the petitioner, Mr. Dayananda Mahapatra, learned counsel to the petitioner, who now appears, states that he's unwell. List on 19th April.
Oh, please.
So my appearance may be kindly recorded.
Yeah.
Opposite party 2 to 4.
All right.
Obliged, ma'am.
Special weekly list item number 21.
Obliged.
Special weekly item number 21.
None appears dismissed. No.
21 minutes I am appearing for opposite party.
All right.
Special weekly list item number 22.
None appears dismissed. No.
I'm for the OP. I'm for the corporation, madam. So,
all right.
Special weekly list item number 23.
My lord, may please lordship. My lord, the sale notice was published by the OSFC for sale of a particular particular land, my lord. So I was the successful bidder. After I was successful bidder, my lord, I deposited the earnest money. Thereafter, the lordship kindly turn to annexure 2, page 2. Page. My lord, the lordship kindly turn to annexure 2. They themselves said that annexure 2 at page 13, my lord, 13, page 13. The lordship kindly it's a short document. I may permit to read it, my lord. The inviting, let's see what it means. The inviting reference to the subject cited above, this is to inform you that we have submitted above demand draft of 50,000 as EMD for the purpose of assets. Sahid the press Bhubaneswar, though sale was finalized in your favor, the same was not confirmed and the above DD is kept with us due to court case pending on the above unit. Thereafter, my lord, what happened, my lord? As per my establishment, the bid was opened and it was sales was confirmed in my favor. I have obtained it under RT Act and I have filed it in the result, my lord. Let's kindly see annexure, the annexure page.
What is the interim order here?
The interim order is not to change the nature and character of the because what has happened with the short question is that after my bid was accepted, I have not been given any chance to deposit the amount and sale was confirmed in my favor, but the sale did not take effect. That is the whole case, my lord.
No, but what is the value of the property today, sir?
Value of the property today might be, but it is their mistake, my lord.
No. You should get it all listed in good time, sir. You can't expect you participate in auction in 2005. And 2022, you will get the property at the same price. No way. 98. What is the date of the auction?
The date of the auction was 2000. Date of the auction was 3197. No,
where's the question, sir? Mr. You will not get it. You can take it from me. You are not getting this property. You pay the market value, you will get it, not otherwise.
Well, you'll also will give me some time. I will obtain the instruction.
No instruction. We'll right now dispose it. You see,
but it is their mistake, my lord.
Whatever mistakes, sir. This is a court of 226. We are not going to let you get a property so valuable for
court of equity.
For a pittance, you can't get a property. The petitioner participated in an auction for purchase of property. For purchase of property put to public auction by the Orissa State Financial Corporation way back in 1997. Full stop. Claiming to be the successful bidder, he came to this court when possession was not handed over. On 9th June 2006, that is 9 years after the auction had been held, an interim order was passed directing the OSFC not to change the character of the property. Paragraph, the petition has been pending for 16 long years here with no progress, with the interim order continuing. Admittedly, the value of the property today is much higher than what it was when it was put to auction sale. Paragraph, although Mr. Mishra argues that it was the fault of OSFC that the petitioner was not handed over possession, the question of the court allowing the petitioner to take over possession on the basis of the bid submitted by it 25 years ago for the same property simply does not arise. Paragraph, it will be open to the petitioner to make an offer to purchase the property at the current market value. If such representation is made not later than 4th April 2022, it will be considered on its merits by the OSFC and appropriate orders passed on it thereon after hearing the petitioner not later than 9th May 2022. The court makes it clear it is not expressed any view in the matter. The interim order stands vacated. The petition is disposed of.
In the meantime, they may put it to sale, my lord.
Well, let them, sir. There's somebody ready to buy today's
my application, my lord.
You take part in that new auction, sir. You take part. Yes.
Special list item 24.
None appears dismissed on numbers.
Special list item 25.
None appears dismissed on numbers.
Special list item number 26.
May I please your lordships, in this item,
Your Lordship will see there has been a preliminary counter affidavit filed in the month of
What's the matter about, sir? You tell us.
2021. State Administrative Tribunal judgment is under challenge.
Tell us what it is about.
Opposite party 4, 6, 15 and 16, they have also filed a counter in 2021.
Forget counter rejoinder. Tell us what the matter is now.
My lord, the tribunal judgment, a batch of case was preferred before the tribunal by some private parties who does not belong to the cadre. There are two things, my lords. Here we are governed under the Orissa Engineering Service recruitment rules.
How many of you are still in service?
We are working, all of us are working. We have got 4 more years to go for service.
All right.
We are now continuing as work charge executive engineers. These are all graduate engineers. There are 4 more years to go for service. So they are continuing in service. That is the development which have taken place in between. All of us have been subsequently considered. And in the work charge category, by virtue of the interim order passed in IA, wherein your lordship had directed, it would not, dependency of the writ application would not be barred to consider them in the work charge establishment. Initially, my lords, all of these persons were appointed as NMRs on NMR basis as graduate engineers, that NMR basis on a consolidated pay. Subsequently, my lords, in the year 2004, we were considered to be absorbed. We were considered as graduate engineers on contract basis. We were given our appointment for a consolidated pay of 7,000 rupees. Well, there are two systems of, the criteria is, the recruitment criteria is that the direct quota is 67% and the promoted quota is 33%. Some junior engineers who belong to the promoted quota, as per the rules, they are guided by their own rules. That is Rule 7, which speaks that 33% quota. So like a public interest litigation, without any locus standi, they came up and filed an application in the tribunal. And the tribunal, my lords, with due respect, my lords, the judge there is Justice Mr. H.P. Das, who is no more, Varaprasad Das, a literature, gentleman in literature of the record. He was basically an administrative member. He has gone on an analysis. He has analyzed entire thing in paragraph 7, and he has gone beyond the records of the prayer of the applicants. What the applicant approached. On paragraph 8, he has given a conclusion that was not even the prayer in the original application. Here, my lords, your lordship will see, I am taking your lordship to Rule 7. First of all, your lordship may kindly have a look at the recruitment rules. Rule 7 of the Orissa Service of Engineer Rules.
You've not quoted it anywhere, sir.
My lord.
Have you quoted the
Orissa Service of Engineer Rules 1941, Rule 7.
Mr. Atha, have you quoted that rule in your petition?
Correct, actually. That rule I have not quoted. It's all there in the miscase. There is, I have not put. I have this Orissa Service of Engineer Rules 1941, which was been subsequently amended. But we go to the prior to the amendment, Rule 7 may be kindly seen. Rule 7. Rule 7. The vacancies to be filled up by promotion of junior engineers shall be so fixed that the promoted junior engineers do not exceed 33% of the total strength of the permanent and temporary assistant engineers, including the leave and training reserve, at the time of each promotion. The remaining vacancies shall be filled up by direct recruitment. Here, my lords, there are 67% of the quota belongs to direct recruitment, 33% of the quota belongs to promotees. These applicants who were filed moved before the tribunal, who are the opposite parties here, they belong to the promotee quota. They were appointed as junior engineers. And their procedure is that if they want to come to the direct recruitment, then they have to come through PSC, Orissa Public Service Commission. Through PSC, that is their mode of recruitment, direct recruitment. Other than that, there is no mode of direct recruitment. And the only relaxation which is permissible to the promotees are under Rule 9, their age will be relaxed. Now, your lordship may kindly see the qualifications for direct recruitment, Rule 9, may kindly be seen. A candidate for direct recruitment to the service must not be over 28 years of age and under 21 years of age on the 1st day of August of the year in which applications are invited, provided that the maximum age limit may be relaxed in respect of the candidates belonging to scheduled castes and scheduled tribes candidates with approved military service and such other categories to such extent as the government may by special order specify from time to time. Provided further, this is what is important, provided further that the maximum age limit may be fully relaxed in respects of candidates who have entered state government service as junior engineers within this prescribed age limit B without the qualification prescribed under clause D of Rule 9 and have subsequently acquired the same while serving as such. So, my lords, as far as Rule 9B, the only method of direct recruitment, if you are interested to come, that is by way of age relaxation. If they are all diploma holders, these junior engineers, they are diploma holders, and in between, if they acquire the qualification, they become graduate engineers. Now, for the graduate engineers who are continuing in the cadre of a junior engineer, they should have 10 years, should have put in 10 years of service to be considered for promotion to the post of assistant engineers. And if they want to compete along with the direct candidates, then they have to, within that 67% quota, then they have to come through regular PSC, which has also been provided under the rules. The selection is by way of PSC, Rule 16. Criteria for promotion. That is the departmental for appointment to the service, the vacancies to be filled up by promotion in the particular year. So virtually, they had no grievance because the state government took a decision. Right from the year 1992, there was ban due to recruitment process. No recruitment was going on. The engineers were on roads. They were trying for some job, but nothing was given to them. So the government decided that on NMR basis, they had on a 1,500 rupees, they will be just be bought over and will be continued. And some persons where engineers were appointed as stipendiary engineers also under consolidated pay of rupees 2,000. Subsequently, government came up with the Validation Act, which was subsequently challenged. And these stipendiary engineers as one-time measure were all regularized. And these petitioners, my lords, they continued as NMR and DLR basis. And in the year 2004, a decision was taken by the government to bring over this graduate. All of these are graduate engineers on purely contractual basis for a period of 1 year. They were asked to be appointed in the post of regular sanctioned post of assistant engineers. And that appointment order was challenged by them. Your lordship is aware of that how can somebody, unless it is a writ of quo warranto or something that under the tribunal, those persons who don't have any locus standi, the order which has been cancelled, Your Lordship, 7976 is the order that has been set aside by the tribunal. One, that is absolutely wrong because it can, time and again, Justice B.N. Agarwal decisions, a number of decisions, even Justice Fasayat has also categorically stated that persons who are not aggrieved by way of a public interest litigation, you cannot challenge somebody else's appointment, and that else's appointment is quashed. Not only that, the tribunal also went beyond their prayer. So all these findings and the concurrent things are all illegal, my lords. They are liable to be set aside. One, your lordship may kindly see the order which has been quashed.
What was the interim order here?
Well, interim order there was in
here, sir. In this court, what was the interim order?
In this court, what was the interim order?
23/9/2007. Any action taken shall be subject to the final decision of this.
No. If the appointment has been set aside, then where's the question of any action taken? What did the tribunal do? It set aside the appointment.
The tribunal set aside the appointment. No, tribunal has not set aside the appointment. Your lordship may came to the finding part. These are the three findings which the tribunal has given. May I take your lordship to page 14 of the judgment? In the background of the above observations, we are constrained to conclude that until the rules are amended, the current rules alone would continue to govern the fate of the applicants, and that no NMR DLR employee can be allowed to fill off regular. Paragraph 8 is the conclusion.
So you're all continuing basically.
We are all continuing.
Despite this being an ad hoc appointment.
This was purely a contractual appointment.
In this petition, you want substantive relief. You never went to the tribunal. The other side went to the tribunal.
Other side went to the tribunal.
And now in this petition, you want substantive relief for regularization.
We have come here in this.
I like that.
We have come here to. .04 of 2004. These two applicants, they were.
Just see what the tribunal has done is something quite extraordinary. After quashing your orders, it says it would not affect the continuance of the affected persons as DLR engineers. I've never seen such orders. Extraordinary orders, these are.
Yes, that is exactly.
Actually, state should have come and appeal.
No, the state government has supported.
They are very happy letting you continue like this.
But thereafter, when they have set aside the tribunal, your lordship will. One is by way of direct recruitment as junior engineers, and the second is 67% quota, where from the market directly you come over.
Yeah.
What has happened? We were given appointment, not appointment. We were engaged.
You didn't come through any selection.
Yes, my
you
lord.
came in as a non-muster role.
My lord, your lordship will see from 1990 we continue.
Oh, tell us one more thing, sir. Come to page 60. 60.
Actually,
60. You have the paper book.
No, I've got a.
All right. Page 60.
Yes.
What has happened in that OA 2694?
That is a, well, applicants who are now the respondents in this petition, who we have challenged the tribunal judgment, they said that we have been officiating in the post of assistant engineer. reversion in their case. And in that case of reversion, the OA was filed.
So anyway, you're not concerned with that now.
We are not concerned with that.
So you're
they were-
concerned with A and B.
We are concerned with A and B, the findings which, and the development which are the OA has been filed by the applicants during the pendency of this writ petition.
Infructuous. then.
Executive engineers.
Then this
it has
whole
not
thing is
become
infructuous now, sir.
We are concerned with these two paragraphs. Your Lordship, these two paragraphs have to go.
What has
Otherwise-
happened to that OA being allowed? Have they challenged that, the state?
No, my lord. No instructions.
No, no, no.
Especially the
He will
private-
know, sir. The OA which for regularization is allowed, you just now said.
Filed by this applicant.
The present petitioners filed a separate OA for regularization, correct?
For regularization during the pendency before the tribunal.
And that got allowed.
That OA was allowed. That was never challenged by the opposition.
So it has been implemented.
That implementation contempt is pending. We had filed a contempt.
So
and then
all
second
that, sir, you
contempt.
pursue that then. Then why should we break our heads on this petition?
With this petition, to the limited extent, my lord.
Notwithstanding no stay here, you have continued all these years. Your regularization has also been allowed. You have also filed a contempt. The state has not challenged the OAT's order. What more can you want?
My lords, what I want your lordship will see, this,
Yes.
this finding must go.
Nothing
The finding which is standing 8A, the finding.
Yes.
This, can I place the finding? Your lordship may see the findings.
So in fact, the tribunal itself is not restrained by its own order like this. In a subsequent OA, it has allowed your regularization. In a subsequent OA, the tribunal should have said, we have already rejected this prayer in this earlier matter.
The tribunal has directed that you formulate a policy, take a policy.
Exactly.
decision, formulate
The
a scheme
tribunal
and
should have
regularization
said,
services.
the tribunal should have said, we have already given a positive direction not to regularize. How can we now entertain this application? The tribunal should not have entertained our application.
That is one aspect.
What is that aspect? Which means the tribunal is not serious about its own order. In this petition, the challenge in this petition is to an order where the tribunal actually says, don't regularize their services. Despite which, in a subsequent petition filed by you, your petition has been allowed and asked, they've been asked to regularize your services. And this state has not challenged it.
The state has not challenged it. That has become final.
Yes.
That has become final.
Exactly.
And we have
So
4
why
more
should
years to
why
come.
should you pursue this, sir?
The pursue for the only this purpose.
Just imagine if we now dismiss this petition of yours, what will happen? You think about that. If you want to argue this, by all means argue. But then when we are about to dismiss this petition, don't say we don't want to press. Petition will go.
That will go. That is
Ah.
correct. That is
Do you want to protect that or you don't want to protect it?
I want to protect that. I want definitely. That observation may be given, that subsequent development.
Counsel to the petitioner states that in a subsequent development, these very petitioners approached the Orissa Administrative Tribunal with petitions, with an application seeking regularization of their services. And that
regularization, my lord, one moment. During the pendency, there is an interim order passed by this honorable court.
Right. What was the date of that order, sir? What is the date of that OAT's order?
Well, that High Court honorable court has passed.
I understand, sir. I am asking you a question. You please answer that question. What is the date of the order of the OAT allowing your regularization application?
If your lordship may kindly pass over it, I can give the details data. It is in the mobile. Sorry, my lords. Because that another set of lawyers were engaged in that. I am giving it. If your
And
lordship.
that order allowing the OAT has attained finality since the state government did not challenge it.
16?
That is
He
my lord.
states that
16, my lords,
That has been
16/5,
annexed.
2018.
That has been annexed by the
16
intervener.
16th May 2018. It appears that the state government has not challenged that order and it has attained finality. He adds that a contempt petition has been filed seeking implementation of that order, which is still pending. Paragraph. It may be noted here that when interim order passed by this court in the present petition, it had been clarified by this court that notwithstanding the present petition, the case of the petitioners for regularization can still be considered. So it appears that it is pursuant to the said interim order that the above developments have taken place. Paragraph. In view of the above developments, counsel the petitioner seeks not to press the present petition with liberty to pursue the contempt petition which is stated to be pending. The petition is disposed of with the above liberty.
So we will list item number 27. Item number 27.
None appears to dismiss an opposite.
Special utility item number 28. Item 28.
I am appearing for the bank, Lord. Let's become Lord settle and they have paid the amount, Lord.
Counsel for the bank states that the petition has been rendered infructuous, it's disposed of as such.
Blessed.
Special utility item number 29.
None appears to dismiss an opposition.
Special utility item number 30.
None appears to dismiss an opposition.
Special utility item number 31.
Item 31, my lordship, no instructions. No instructions disposed of as such.
Special utility item number 32.
None appears to dismiss an opposition.
Special utility item number 33.
33 were not infructuous, my lord.
All right. Dismissed as infructuous.
Special utility item number 34.
My lord, this appeal has become infructuous because the students, the admissions, everything has been over long since.
All right. Counsel for the appellant states that the petition has been rendered infructuous. Appeal has been rendered infructuous, disposed of as such.
Special weekly list item number 35.
None appears to the appellant, dismissed from opposition.
Special weekly list item number 36.
36, my lord, no instructions.
No instructions disposed of.
My lord, I am for the opposite party.
All right. Dismissed. Sorry.
Special weekly list item number 37. Special weekly list item 37.
None appears for the appellant. Dismissed from opposition.
Special weekly list item number 38.
2 o'clock. All right.
Special weekly list item number 39.
39, my lord, second item and seventh item, they're all infructuous.
Infructuous.
All have become infructuous in view of the judgment rendered by the Honorable Apex Court in common cause case reported in 2017, volume 9 SCC 499.
In view of the judgment in common cause 2017 9 SCC 499, all these petitions have been rendered infructuous and are disposed of as such.
We are appearing for Paradip Porters in some of the cases for a private party.
All right.
My lords, in sub item 2, I am appearing for the opposite partner on 1 and 2, my lords.
All right, sir.
For OP number 11, my lord, I am appearing in first item.
My lord, item 37. Sorry.
All right. 37. Yes, sir.
My lord, here the petitioner, my lord, belongs to the scheduled caste community, whereas the private opposite party belongs to the general caste community. My lord, under section 23 of the OLR Act, that any salary executed by the scheduled caste community in favor of the non-scheduled caste community, the permission under section 22 is must. Without permission, any alienation is void. And the Tahsildar, the revenue officer, declared the sale deed void by imposing cost with the 18% interest. What happened? The private opposite party prefer an appeal for the sub-collector.
Sub-collector, I think in a wrong side of mistake, said the original record is not traceable. So he has also drawn the evidence of one section officer. Thereafter saying, yes, there was a permission. But this matter also carried to the collector in the revision. Collector brought the original records. That is there. But the collector says totally, absolutely there was a fraud. No permission, nothing was there. And he has also confirmed the order passed by the revenue officer, the Tahsildar. My lord, against that order, against the order of the collector, the revisional authority, that the private opposite parties have preferred an appeal, they preferred the writ petition here. My lord, without, my lord, the ignored by the honorable single judge. And under section 22,
not serve the other side. Who's appearing for the other side?
notice has been issued since long.
May have been issued, sir. There's something called service of notice. Have you served the other side?
Yes.
No.
Yes, Mr. Ponda was there. He was appearing for the writ petition.
Just show him the remark.
Some more.
Office notes.
Not
Just
should
show
be
him.
not should be see the noting, my lord.
No, no, no.
Requisite-
Let him see. Let him see.
Yes. Requisite for
Please see the
express-
notice. Noting. No need to turn pages. Right there. The first page noting is there.
My lord. My lord. Limited. My lord. My lord. It will take care of some other.
No, no, no. You say way back on 18th August 2014, notice was directed to issue in the present appeal. Till date, even the requisites for the purposes of notice have not been filed. The appeal is dismissed for non-prosecution.
My lord, it's a wrong order. Because this Tahsildar is in my favor, collector is in my favor.
All right, all right. Yes.
Special weekly list item number 40.
My lord, this case is, my lord, the first case is covered by another judgment of this honorable court, my lord. My associate is there. He is handing over the copy of the judgment, my lord. This is a case where the demand has been made after the delivery by the railway. And this honorable court has passed that demand and said that no, there cannot be any invoke section 77, 72 of the Railways Act. There cannot be any demand after delivery. So that judgment, your lordship, kindly look at me.
Yes. Who's for the railways?
My lord.
So it's covered by this order?
I will verify that. I will verify that.
No, no, no. You either do it right now. You must have appeared in that matter also.
Just now there's.
No, no. It's okay. This is a judgment, sir. This is not some petition of pleadings. Yeah. If you want to go through it, we'll pass it over. Go through it. Which items are covered by this order, sir?
Only the first item, my lord.
Only the first item.
One for
What about the remaining? What about the
remaining, my lord? Remaining, my lord. So that 788 and 12084, they are in the same. They are on the same footing. Then, my lord, what had happened? The rake was loaded. So the rake was weighed in a defective weigh bridge, and that has been admitted by the railway in their counter. And if it is defective, then they cannot charge any penalty out of that. You also kindly see that I straight away take a lordship to the counter filed by the railway, page 19. Page 19. During very same period. Well, because on our objection, when I found that the weigh bridge is defective, we immediately complained and they immediately came and found out that. Page 1919, my lord. Para 12. Let's see what it, my lord.
Yes. In reply to government.
Made in part 9 of the application, it is humbly submitted that on receipt of the message from the authorities and in the in-motion weigh bridge of Mandir has heard the assistant division mechanical engineer DIG visited the site on 18/5/2019 and suspended the weigh bridge and called the service engineer for necessary checking of the weigh bridge. The service engineer attended the OABs on 24/5/2009 and noticed that the track switch mounting was loosely connected and the system zero scale parameter was drifted.
So when was your consignment made?
That was on 17/5, my lord.
17/5.
Yes, my lord. And it was on 18/5 they came and found that they suspended the base. They filed the
Yes,
report also. The report
what do you
is
say to this now?
My lord, page 2 of the counter, my lord. Paragraph 6, my lord.
No, what do you say to para 12?
My lord, they are overloading the wagon.
What do you say to para 12, sir? He is arguing para 12. What is your response to that?
Para 12 of the counter, my lord.
Yes, please. He just now read out.
That is reply to Amendment 9 is the repeated submit that the receipt of the message from the authority in motion overbridge, the assistant division manager engineer TH visit the site on 8/5/19 and suspended the overbridge and called the service engineer for necessary checkup. The service engineer attended the overbridge at 24/5/9 and noticed that the track switch mounting was loosely connected and the system zero scale parameter was detected. Same was immediately attended and the OA machine was brought to the working condition. The report of the service engineer dated is annexed C/1. My lord, my C/1 report.
Yes.
What do you have to say to this, sir? It's an admission that your weighbridge was not working properly.
There are rectify that.
Rectified later when his consignment was weighed on 17th, sir.
Yes.
His consignment was weighed on 17th May.
That was rectified on 24/5.
So which means what was weighed on 17th May was defective. It's a clear admission.
Page 9 of the counter. 4. This court official arranged the test wages and the system with the test wages, the system track done in the both destroy and reading all with the limit. Now system working with the satisfactory.
So you have admitted that was
page
defective.
10, next page 10. That is the letter to 15/5/9. Page 10, my lord.
Subsequently, that was rectified. You admit in your counter that that was defective.
No, that was rectified on 15/8/2005.
So the date of weighing is 17/5/2009. That's the date of the weighing.
My lord. My lordship, page 10 of the counter, my lordship glance.
All right.
Joint report. That is the my lordship, as a moment, my lordship glance. That is the date 15/8/2009.
Which is 3 months later, sir. You're not getting your dates correct. This is what the problem is.
Apart from that, they are not complained that they are on 17/5/9 that has been defected.
Yeah. So you yourself went and checked the machine on 18th and then you rectified it only on 24th. What are you saying? The challenge of the present petition is to a penalty demand raised by the railways on the petitioner.
May I pray one thing? May I intervene, my lord? May I interrupt, my lord? I may be permitted.
Yes.
Yes, my lord. This other matters there. If lordship permit, then we will give a short note to the charge. Then lordship may pass the order. It will be better because yesterday evening we got the files.
No, the person just now argued is fully ready.
No, he is ready. One first case is.
So let's do it.
Different council.
All when we call out a case, you can make a submission. This is in 7/888 of 2009. The challenge of the present petition is to a demand for penalty raised on the petitioner for alleged overloading of the wagon used to transport bauxite mined by the present petitioner. Instead of mind, you say bauxite, which was moved from Hathband in state of Chhattisgarh on 16 May 2009 and moved towards Doikalu in Orissa. Paragraph. Since there was no weighbridge at Hathband, the rake was weighed at Mandira South weighbridge in the Sambalpur division. The overloading was detected as 669.14 metric ton. And accordingly, the penalty raised was Rs 1521,223. Paragraph. The case of the petitioner is that the weighing machine was not correctly working and that it is not practically possible to load 4611 metric ton in a rake. Stop. Consequently, the transport company requested opposite party number 2, that is the station master at Mandir Hazaud in Sambalpur division, to have the machine itself checked out. Paragraph. Now, from the counter affidavit filed by the railways, it transpires that pursuant to the above complaint, the machine, when checked, was found to be defective. Full stop. This is clear from para 12 of the counter affidavit, which reaches under. Reproduce the whole of para 12, page 19. Paragraph. Learned Counsel of the Railways took the court through other paragraphs in the counter affidavit, all of which confirm that the machine was set right only subsequently. First on 24th May 2009, then again in August 2009. The fact of the matter, therefore, is that when the rake was weighed on 17th May 2009, the machine was not correctly working. Paragraph. In view of the above admission, the impugned penalty raised in the petitioner is unsustainable in law and is hereby quashed. The writ petition is allowed in the above terms. No orders is to cause. The very first matter. Have you seen this judgment now, sir? Just see it in the meanwhile. Yes, Mr. Padi, you're in the third matter.
Same matter, but dates are different counter evidence file. In case number, let's say 12084/2009. It is different counter.
Same weighbridge. It is just a few days.
Same counter evidence. As regard to the para 10 is concerned, there is a different stand has been taken by the department.
Saying what?
May I read it by now?
Yes, please.
The contents of the para 10 denied it is submitted that the varies of section 73 of the Act. It is not under the challenge here. The petitioner has challenged their demand since the word cannot be set with the binding. The date of outage is admittedly from 22/3/2009 to 28/4/2009. That was the only plea we put in this counter.
But same station, sir.
But Lordship has clarified that the date that was.
Mandir Hasaud, the same.
And page 168, they have made this statement, same statement.
Same thing.
Same thing.
Almost all are same. Almost all.
Then all the others you say, in view of the order passed today in 7/888 of 2009, the impugned demands in all these petitions are hereby quashed. The first matter you say, in view of the order dated 12th April 2019, in writ petition civil 6379 of 2008, bracket Vedanta Aluminum Limited was the Union of India. The impugned demand is quashed. No, the writ petition is allowed in the same terms. Accordingly, the amount deposited by the petitioner will be allowed to be withdrawn subject to filing an undertaking to make the payment of the amount due if the issue is decided against the petitioner. All the matters are over. All right.
They are not disputed because of by virtue of this order that was stayed.
Interim order is vacated. All right.
Special weekly list item number 41.
My appearance will be noted in the JNX CGC.
In
item 40.
Yes. Give us your appearance. We'll put it down.
Item 41, I am for the OP4 Paradip Porters.
All right. None appears to the
I am for
petitioner.
the Central Pollution Control Board, my lord.
All right. None appears to the petitioner.
Number 8.
All right. None appears to the petitioner. Dismissal now.
Special weekly list item number 42.
I am for opposite party. I am for opposite parties.
All right. None appears. Dismissal now.
Special weekly list item number 43.
My lord, the matter has become infructuous.
Counsel, the petitioner states the petition has been rendered infructuous. It is disposed of as such.
Special weekly list item 44.
None appears. Dismissal now.
Special weekly list item number
My lord,
45.
item 44, the item may be passed over, my lord.
Whom are you for, sir?
My lord, I am for the petitioner, my lord.
All right. Pass over.
Special weekly list item 45.
May I please, your lordship?
I am for the opposite partner 3, Bhubaneswar Municipal Corporation.
My lord, may I please, your lordship?
Yes, please.
In this case, I have challenged the disciplinary proceeding to be quashed, my lord, initiated by the BMC, by the Bhubaneswar Municipal Corporation. A single judge matter, your lordship.
All right. Counsel, the petitioner says that this is a single judge matter. List before the roster bench on 6th April.
Special weekly list item number 46.
May please. My lord, in this case, the petitioner filed the Learned Tribunal passed the order under Annex 7 under challenge, my lord. Last occasion, your lordship, kindly see the order dated 14/9/2021. Your lordship direct to the state government, take to the instruction and regarding to the produce the.
No, my lord, on last occasion, your lordship has directed the state council to file an affidavit.
Indicating the merit list.
But, Lord, as it appears, Lord, the affidavit has not been filed.
So we allow the petition, sir?
Lord, I'm sorry, my lord. Lords may kindly give me last chance, my lord.
What is the order dated?
14/9/2021.
What about serving opposite party number 4?
It appears that till
No, my lord,
date,
the
opposite party number 4
noting
has
says,
not.
my lord, noting says the fresh notice issued to OP number 4 returned undelivered with postal endorsement redirected to NAMPO.
Last occasion, your lordship direct to the concerned SP to the serve the notice to the OP number 4, my lord.
What is a NAMPO?
It's a place, my lord, in Baleshwar district.
What do we do? He's not served yet. Opposite party number 4.
Private opposite.
Private opposite, my lord.
Have you received the confirmation from the SP whether the notice has been served or not?
Yes, my lord, the file, my lord, I am sorry, my lord, there is no such instruction. In fact, whether the order was communicated or not, my lord.
It
Lord,
appears that the
kindly
opposite
one
party
week
number
time
4 is not yet served. It's still, this opposite party number 4 is still working in the police force, right?
Yes, my lord, yes.
Considering that he's still working in the police force, a direction is issued to the SP Baleshwar to ensure service of notice on opposite party number 4. The requisites already filed be used for this purpose. List on 17th May.
Special weekly list item number 47.
None appears to system.
This matter, let's see, the present petitioner challenges the validity of section 7E and 7F of the Orissa Education Act 1969. On the footing, let's see, that section 456 of the Orissa Education Act 69 prescribes for establishment of school, and 7E and F, which was amended contrary to that, saying that no permission shall be granted to the city school stroke colleges.
Who are you, sir?
Sir,
who are you?
I am for the petitioner.
Who is the petitioner, sir?
Petitioner is the secretary of the college, established in year 1990.
Which college?
Regional College of Science and Technology.
With your lordship's kind permission, may I interrupt, my lord? In my counter affidavit, I filed a decision, my lord, in which case, my lord, this very virus has been challenged, and their lordship has held that this is intra-virus, my lord. If your lordship will see, my lord, the counter affidavit, page 20, my lord. The judgment I have also annexed, my lord. May I place, my lord?
1991 CLT.
My lord. No, my lord. It is
2011 1 CLR.
My lord. It is delivered by Justice S.C. Mahapatra, my lord. Page 20, my lord.
That is 1991 CLT 161.
My lord. Page 20, your lordship, para 4 last line I am placing, my lord. Without anything more, on the face of the materials on record, I am not inclined to declare section 7E ultra virus either on account of legislative incompetence or violative of constitutional guarantees, my lord. So this issue was already held by this Justice.
Answering to the query of my learned friend, let's see, Honorable Court held that since establishing of school and colleges does not come under the purview of fundamental right, therefore the petitioner has got no locus. Now let's see, coming to the TMFI judgment 2001, let's see, in TMFI, let's see, TMFI, Honorable Chief Justice Khare, speaking for all, held lordship that since education is an occupation, falls under the category of Article 19(1)(g). Therefore, establishing and opening of the college by the people or body of the people has got the fundamental right to open the institution. To that, let's see, kindly, I have given the compilation of TMFI judgment.
So we don't have, unless you tell us why this judgment should be reviewed.
In view of the TMFI judgment, this judgment is not binding. This was delivered 91. TMFI judgment of 11 judges came in 2002, holding that 11 judges judgment lordship of the Honorable Supreme Court, holding that education is an occupation. Therefore, it is coming under the purview of Article 19(1)(g).
What does 7E and 7F do? What is section 7E and what is section 7F?
7E and 7F restriction
for private institution for imparting training degrees, my lord. Training
to
education,
the
academics, my lord.
To
teachers training education
Teachers
has been
training
restricted by 7E by private institutions. Only government institutions will provide that.
So what does TMFI to do with that, sir?
Let's see, the judgment cited by my Lawrence friend, where the Honorable Court held, since education is not coming under the purview of fundamental right, education is not coming under the Article 19 of the Constitution. Therefore, locus, the present petitioner does not have locus to challenge section 7E and F. And after TMFI judgment lordship, what I am submitting, establishing of educational institution, and since education has
have
been
you
held,
applied and your application been rejected?
Lordship,
have you applied to set up an education teacher training college and it has been rejected? Have you applied? No. Have you applied or are you intending to apply?
Already we have applied, they have given us permission. Then our students sat in the examination, they qualify. Thereafter, they did not permit us. We filed a writ petition before this Honorable Court in 2011. This division bench of this Honorable Court again permitted our student to sit in the examination. Thereafter, again we filed application for giving us recommendation and affiliation. They did not allow us. Thereafter, we filed challenge this petition by of.
No, but how did they process? If 7E was already there, how did they process your application?
Lordship, during.
How did they even allow you to apply?
Kindly come to.
And another aspect is that, my lord, subject to your lordship's kind indulgence, my lord, after coming into force of my lord, National Council of Teachers Education Act, 1993, my lord, as per section 14, my lord, it is the central government who has to give them recognition. That I have stated in running page 15, my lord.
What my lord asked me, kindly come to page 6 of their counter, lordship. Page 6 of para 9, lordship. Counter filed by my lord and friend.
What was the date of this amendment, sir? 7E and 7F? I think his application was prior to the amendment.
My application, first application was after the
91, sir. Your application 91.
91.
Then you slept over it till para 14 in your own narration. For 4 years, you did nothing.
My first application, they permitted us on.
And then again from 95, look at para 14, 15. This is all very strange. The whole narration is very strange, sir. Just come here. If you start reading from para 9 of your writ petition, you're jumping several years. Very strange. From after 95, we straight go to 2004. After 2004, straight to 2010. Just read paras 14,
during that period,
15, 16. 15 years.
This is of dates. List of dates. During that period, our case is pending before this honorable.
No.
What
is this case? From 95 onwards, what was the case pending?
Lordship, that is, kindly come to counter filed by my lord and friend.
First, we'll come to your petition, sir. There's no narration in your petition.
Page 23, Lordship, it is reported in 2011. Our case that they have annexed, Lordship, it is 2011 1 OLR 287.
Can you answer this question, sir? You come to your writ petition.
The cell did para 5, Lordship.
Para 8, you come first of all. What is the date there?
The course of city certificate is for 2 years, and on being qualified.
What is the date in that paragraph? Para 8, what is the date given?
6690.
Now come to para 9. Next paragraph. What is the date?
24/12/91.
Now come to para 11.
21/2/92.
Right. And para 13 is 8 September 92.
92.
Now come to para 14. Now you'll yourself be surprised how you've drafted this petition. Para 14, one event that happened in 95. Next para 15, something that happened 9 years later. Nothing indicated what happened in these 9 years.
2004.
So what is the gap between 95 and 2004? How many years?
Lordship, kindly come to page 22.
First, you tell us, sir, what is this gap between for 9 years? No narration at all.
9 years.
And then come to para 16. Another 6 years gap. Between para 14 to para 16, you have covered 19 years.
Lordship, during that period, we had filed writ petition.
Where is the narration in your petition, sir?
Lordship, that is order I am placing. What order passed by this honorable court in 3 writ petition that I am placing, Lordship. That gap I am placing the order.
Meanwhile, statute itself has undergone a change. Now you can only apply to central government.
Lordship, what my learned friend is saying, kindly come to the Education Act, Lordship.
Yes.
Mr. Naik, you have also not disclosed that the earlier round of litigation which you are referring to.
Lordship.
To explain this gap.
You have not.
That also you have not disclosed. That too, at the first available opportunity, you never raised the validity of those 2 sections.
Yes.
Now at a belated stage, you become wiser and you are questioning the validity.
Lordship, during what my lord is asking me the pertinent question, Lordship, since I have the dates which my lord is asking, that dates it's covered by the judgment.
No,
which,
nothing
Which
like
I have
that.
not.
You have to first of all set out in your petition all the complete facts.
I'll file the judgment, compilation of the judgment passed by the
judgments will not substitute for facts which you have to narrate in a petition, sir.
Lordship, kindly consider during that period, my client was pursuing case before this honorable court. But since these are the cases and judgments, I did not give the dates. Second,
sorry, sir. Sorry.
Lordship, and compilation, my learned friend has filed
Yes,
the judgment.
yes.
Lordship, kindly come to their counter.
Yes.
They have filed the judgment.
Yes. Even this judgment is in a writ petition of 2010. It's a writ appeal of 2010.
Writ appeal.
And writ petition, it arises from a petition, a judgment in a petition of 2010. So it still does not explain what you were doing for 15 years between 95 and 2010.
They permit us for examination. During that period, they permit.
Sir, don't treat this so casually that anything and everything that you draft without asking questions will simply entertain it.
Lordship, kindly
Yes.
consider this. This is a statutory interpretation.
No.
Lordship, kindly
It's
consider
not
this
merely that. First of all,
purely
you have to come clean on facts.
Lordship, it's a statutory interpretation. My right has been curtailed by virtue of the amendment.
Mr. Nayak, you have to make out a case on the basis of the facts of your case. Then only you can take advantage of the judgment in your favor. Here, it is...
the facts itself are defective,
lacking.
sir. No facts.
Lordship, only what I'll do, only I'll file the compilation of the judgment.
No,
it will cover the whole dates, Lordship.
It will not, sir. It will not. That is your understanding. Just to be filing judgments to somehow make up for facts.
And the
Judgments will not
petition.
make up for facts, sir.
And the read petition.
No.
Because to make it clear, Lordship, kindly come to only I am placing their counter, Lordship. Kindly come how they have denied it. Page 6 of the counter.
Yes.
Page 6. It is opposite to para 9, Lordship, to mention here that the student of unrecognized student cannot appear in city examination as per chapter 9 of the Regulation Board of Secondary Education, Orissa, wherein it has been proved that no school which is not recognized by the board shall be permitted to present candidate for any examination conducted by the board. The present petitioner's institution admittedly is an unpermitted and unrecognized institution, and accordingly the student of the petitioner's institution cannot be permitted to
So
appear.
have you filed a rejoinder to this counter affidavit? When was this filed?
File counter. 2000.
Which year are we in now?
2017. They
Which
filed,
year are we in now?
2022.
For 5 years, you could not file rejoinder.
Lordship, this matter, kindly see the. I have given 10, 20 memos to be listed before this honorable.
What has that to do with your filing rejoinder, sir?
Only I'll file within 7 days.
No. Anyway, that's not even the point. Anyway, these facts are all not denied. The fact that you're an unrecognized institution is not even denied by you. All right.
Within 7 days, I'll file
petitioner has
rejoinder.
approached
What
this
my
court
lord is asking me,
challenging the
I'll show all the documents.
No.
Because, Lordship, I am covered by the.
Everything, sir. Only judgments. According to you, you file compilation of 200 judgments to make up for facts, correct? According to you, no need to set out facts in a writ petition.
My. Now the court's document, Lordship, only I have to place it by way of rejoinder.
All right.
For court's document and the read copy of Lordship.
All right. You said the challenge in the present petition is to the constitutional validity of two provisions of the
Lordship, kindly consider
Orissa
in
Education
two rate petition.
That is section 7.
Lordship, only I am interrupting
Capital
my lord.
E.
In two writ petition, one writ
And
petition
7
was
capital
allowed. Out of two listed today, one writ petition was allowed.
Which read as under. Reproduce 7E and 7F. Paragraph. Earlier, the virus of these provisions, the virus of section 7 cap E of the Act was upheld with this court by a division bench of this court in governing body Balyapal College of Physical Education versus State of Orissa, 72 bracket 1991 CLT 161. Paragraph. In the counter affidavit filed in response to the present petition, apart from pointing out that the above decision covers the issue against the petitioner, it has been stated that there is another judgment pertaining to this very petitioner addressing against the petitioner its prayer to take on new students for CT certified teacher.
Certified training course.
Certified training course in full stop. That decision is State of Orissa versus All Orissa Private Secondary Schools Management Association, 2011, 1 OLR 287. Paragraph. The third fact which has been mentioned in the counter affidavit, which has again not been disputed by the petitioner by filing any rejoinder affidavit, is set out in para 9, which reads as under. Reproduce on page 37. Paragraph. Counsel, the petitioner states that since the matter was not listed before this court after the counter affidavit was filed in 2017, he could not file a rejoinder. Paragraph. This court is unable to appreciate the above contention. The filing of a rejoinder was not dependent on the petition being listed in the court at all. Paragraph. Counsel, the petitioner then wants time to file rejoinder. The court does not consider the request to be reasonable, since there was sufficient time for the petitioner to file a rejoinder. Paragraph. Counsel for the respondent further points out that apart from the fact that section 7E and 7F of the OE Act do not permit establishment of teacher training institutions by private bodies, the whole issue of establishing teacher training institutions is now in the domain of the central government by virtue of the
section 14 of the National Council of Teachers Education Act, my lord.
By virtue of section 14 of the National
Council of Teachers Education Act, NCT Act.
NCTE Act,
1993, my lord.
National Council
read with regulation
for Teachers
7.5 of the
Training
National
Act 1993 bracket NCTE Act. Paragraph.
Read with my lord, regulation 7.5 of the National Council of Teachers Education Recognition Norms and Procedures Regulation 2000.
Where are you reading, sir?
My lord, page 15, my lord, of my counter affidavit.
Page 50.
15, my lord.
All right. Section 14 of that act, read with regulation 7 bracket 5 of the National Council for Teacher Education bracket Recognition Norms and Procedure bracket Regulations 2014, framed under section 32 bracket 2 of the NCTE Act. Paragraph. In view of all of the above factors, there is no merit in this writ petition and it is dismissed as
But
such.
my learned friend is saying that is wrong in lordship. That is wrong because lordship, so education comes on the concurrent list, lordship, and 25 says lordship. It is not the power, lordship.
All right.
Special vehicle list item 48.
48, no instruction of counsel. Petitioner states there are no instructions. Dismissed as such.
Special vehicle list item number 49.
59, my lord, regarding listing of the case, after 10 years it has been listed. Sorry to say, I have sent registered letter today. Sometime your lordship, my lord, so that I will be ready and have the matter.
No. What's the matter about, sir?
Matter regarding the punishment awarded in the disciplinary proceeding. That some time is required because I am not ready with the brief. I have sent registered.
We are not
letter to
adjourning
the
matters.
petitioner, my lord.
We are not adjourning. Come to the petition. We are not adjourning the case, sir.
I'm not ready.
Counsel, the petitioner is not prepared to argue the petition. Considering it's a 2012 matter, the court is not prepared to adjourn it.
My lord, I have sent registered letter today to the petitioner, my lord.
Dismiss for
Your lordship
non-prosecution.
kindly consider, my lord.
Dismiss for non-prosecution.
Pass over. Special weekly list passed over matter item number 1.
Yes, please.
May I please your lordship?
Yes, please.
In item 1, my lordship, I may be permitted to place this matter on behalf of Mr. B. Rautray.
All right.
My lordship, on 31/10/2000, my lordship, I have given a date chart, your lordship.
All right. Let's see that. Yes, please.
My lordship, it is a matter arising out of Provincial Insolvency Act 1920, your lordship.
All right.
Before the Honorable Single Judge, an appeal was preferred by the appellant under Section 75(3). I believe your lordship has the act of the.
No, first tell us the facts and then we come to the act.
Yes, your lordship. In the year 1922, a suit for partition bearing OS number 30 or 22, in which the Nadia Gaji residential house was one of the items of the suit property, was filed by one A.C.H. Appala Narsingh Chetty against his brother. In 1927, my lordship, preliminary decree was passed and subsequently final decree was drawn up. In the year 1933, one of the creditors, N. Lingaraju, filed an application under Section 9 of the Provincial Insolvency Act in IP case number 1033 to declare Appala Narsiya Chetty as his son A. Ramarao as insolvent. 1634, my lordship, this date is relevant. A. Chappala Narsiya was adjudged as insolvent and the application against his son A. Ramarao was dismissed to declare him as insolvent. In 1935, A. Ramarao filed a suit bearing original suit number 535 for partition of the land which had fallen to the share of his father. In 1641, my lordship, the insolvent procedure was annulled under Section 37 of the IP Act. In 1950, my lordship, A. Chappala N. Chetty died in 1950. In 1964, A. Ramarao filed a petition in IP number 1033 to be included as one of the creditors. That was allowed by order dated 20/69. In 1669, my lordship, A. Ramarao and the heirs of A. Buchaya Chetty filed petition for compromise on 1669 in IP case number 1033. In the said compromise petition, the Nadia Gaji residential house was also one of the items of the property, which was just falling in the share of the present appellant, your lordship. 1769, the insolvency proceeding was disposed of on the basis of the said compromise, though at the time A. Ramarao was in the hospital as indoor patient.
Whether he was in a proper state of mind.
1874, your lordship, A. Ramarao filed a petition to recall the order dated 7569 on the ground that the fraud has been practiced on him and that apart, the insolvency court has no jurisdiction to record compromise after the insolvency proceedings are annulled. Thereafter, my lordship, on 13/4/83, the insolvency court allowed the application of recalling the compromise filed by the A. Ramarao on the ground that the insolvency the court has no jurisdiction of compromise once the same has been annulled. The same order was challenged before the Honorable Single Judge in Miss Appeal number 274 of 83. And my lordship, the same Miss Appeal was allowed by order dated verse 94. And against that order, I prefer this AHO, your lordship. My lordship, may kindly see page number 8 of the judgment passed by the Honorable Single Judge, your lordship. Page number 8, para 7. If your lordship will permit, I will just place the paragraph.
Let's hear the main appeal itself, sir.
Yes, my lordship, this is all relevant. That's why I'm treating your lordship.
Yes.
The page number 8, para 7 of the Honorable Judgment of the Honorable Single Judge, your lordship.
Yes. With the leave of my lord to assist the court. Paragraph 10 and 11 of the impugned decision, the Honorable Single Judge has categorically dealt with the matter whether the recall power is there or not.
Correct.
Honorable paragraph 10 and 11 started from type 10.
With respect to learned senior, prior to that, my lordship have to adjudicate the first issue. That is with 75.3, your lordship. 75.3 specifically states to take leave before filing an appeal, either by the district judge or by the High Court, my lordship. In the present case, that's why I'm relying upon the paragraph 7, your lordship.
Yes.
In paragraph 7, my lordship, the appeal was first admitted, then the leave was sought for.
Doesn't matter now, sir. This distance in time, we're not going to go into all that. Yes.
The Honorable Single Judge has taken note of it, and page 9 he has given his finding to the why the leave has been granted by the Honorable High Court.
Correct.
That is the reasoning, my lordship. Without giving the reasoning, my lordship, that has been allowed. I will just place 75.3, your lordship.
All right.
Deals with appeal, your lordship. 75.2. Any such person aggrieved by any such decision or order of a district court, as is specified in Schedule 1, come to or made otherwise than in appeal from an order made by subordinate court, may appeal to the High Court. 3. Any such person aggrieved by any other order made by a district court, otherwise than in appeal from an order made by a subordinate court, may appeal to the High Court by leave of the district court or of the High Court. In the instant case, your lordship, my lordship can be referred to para 7.
Yes.
The appeal was preferred. In this, my lordship, they have asked for the leave after an objection was made by us, your lordship.
All right. Anyway, the leave is granted ultimately.
Yes, your lordship.
Yes.
But it has been made otherwise.
That's all right.
That is my first contention, your lordship.
All right.
The second
what is wrong with the other? What is otherwise wrong with the impugned order?
Yes, your lordship. Now the issue remaining to adjudicate before your lordship is the order which has been recalled. Either the district has the jurisdiction or not. The recalling is, my lordship, the order dated 759, your lordship. That has been made on the basis of a settlement, my lordship, between the parties, which now the president appellant says has been made without his consent. And the Honorable Single Judge at page number 10, para 10, has dealt with the issue, your lordship. The only question that arises for consideration is as to whether the order passed by the insolvency court on 7/5/1916 is with or without jurisdiction, your lordship. And the ultimate conclusion of the Honorable Single Judge is as page 15, para 14, your lordship.
There is yet another aspect.
My lordship. ultimately they held that because necessary persons are not implicated in that proceeding, the same should not have been recalled, Your Lordship.
Correct.
But my
So many
case is,
steps have already been taken, sir.
My Lordship?
So many steps have been taken. It was a compromise petition filed by you, which you are trying to resile from.
That is the issue, Your Lordship.
Yes, yes. And who's going to adjudicate whether in 1969 you were in a proper state of mind or not?
At page 13, my Lordship.
When you wake up after 5 years, 74, you might file a petition saying I was not in a proper state of mind.
The same has come to my mind, also my mind, Your Lordship. But at para 13, my Lordship, the honorable signatures has stated that considering the order dated 1969 not to be an order recording a compromise, I do not feel the necessity of going to the further question asked on behalf of the respondent.
Yes. Yes.
So, my Lordship, that compromise has not been given, the compromise has not been taken into consideration by passing that order.
Yes.
And specifically, my Lordship, my case is after section 37, once the proceeding is annulled, the discharge becomes functus officio, Your Lordship.
Right.
Though, Your Lordship, I have some judgments, but I have not made what on record, Your Lordship.
Right.
37 states proceedings on annulment. When an application is annulled, all sales and dispositions of property and payments duly made, and all acts theretofore done by the court or receiver shall be valid. But subject as aforesaid, the property of the debtor who was adjudged insolvent shall vest in such person as the court may appoint, or in default of any such appointment, shall revert to the debtor to the extent of his right or interest therein, on such conditions, if any, as the court may by order in writing declare. Your Lordship, the appellant here is the son of a person who was declared as creditor, Your Lordship.
Right.
And now the person who was declared insolvent was his father. Now that father, in view of the settlement, my Lordship, he has given away the son of his property of his son, Your Lordship, by way of settlement. That's why we have come into this appeal, Your Lordship.
All right. All right. Orders reserved.
I am my appearance respondent.
My Lordship, may kindly permit me to cite all the judgments and give a detailed note of submission.
Yeah,
Your
yeah.
Lordship.
Both parties are permitted to file their respective written note of submissions within 1 week. All right.
Grateful, Your Lordship.
Pastor matter item number 44.
But I am there, my lord. Item 44. my lord.
Yes.
With Lordship's permission, my lord.
Yes.
Sir, this is actually IDCO's writ application challenging the award passed by the presiding officer Industrial Tribunal.
Right.
If your Lordship kindly appreciate that IDCO is a creature of the IDCO Act, my lord. It's a statutory body.
Right.
In fact, I have not taken any stand from the earlier point of time that IDCO is not an industry as such, but IDCO is not an industry. And here in this case, what has happened that this
this is an industrial award.
Industrial award.
So how is the writ appeal maintainable? Because writ petition is decided at 227, sir.
The writ application filed, my lord.
That's right. No. Writ petition was 8856 of 2010.
Yes, my lord.
Against the judgment of the single judge in this writ petition against the labor court award.
Yes.
No writ appeal is maintainable, sir.
Writ appeal has been disposed of already.
Then what is
It has come to remanded the matter to the writ stage.
I see.
They have remanded the matter.
I don't know how writ appeal should not have been maintainable at all.
Well, actually, they have remanded the matter for fresh adjudication.
All right, tell us, how old is this employee now?
Sir, nobody is in employment now. Since the last 25 years, nobody is there. They were all appointed by different contractors at the different project level. Because IDCO used to execute works for different industrial sectors in different...
Then we'll just leave the questions of law open, sir.
So here what has happened, well, if Lordship kindly appreciate, nobody is there since the last 25 years in employment.
But
Why
should we then adjudicate all this?
They have to indicate whether they are gainfully employed or not in the meantime, or they are still unemployed.
Right.
They have not filed an affidavit to that effect, madam. But there are 2-3
We can just leave the questions open, sir. Because no point in adjudicating these things.
So here actually what has happened, but the question of absence, there is no permanent post in the corporation. But your Lordship knows that in the event actually there is no permanent post is available, then the only alternative is actually if they can be compensated. But here, interestingly, no employee came forward to file an application before the industrial tribunal. It is the Karmachari Sangha. They represented 80 persons, but actually at the time of adjudication, they confined it to 43. And eventually the matter was adjudicated.
The present matter is, I'm not able to understand.
Tribunals 2010.
No.
Page 25 is the award ballot.
No, what has been listed last two occasions is some 12749 of 2019 IA. What is that IA? So their application for disposal of the
then that was carried to the Supreme
in terms of this 26/7. That is over, I think. All right. You say 12749 2019. For the reason stated therein, the application is allowed. The writ appeal is taken up for hearing. Writ petition is taken up for hearing. Yes. What were you saying, sir, Mr. Mishra?
If your Worship looks at page 25, annexure 3.
Yes.
Number one, sir, no individual actually appeared before the tribunal.
So none of these workmen are around, correct?
But they are not working, madam. None of them are working actually.
So what is the relief granted to them?
So relief they have granted for directing to
regularize. Now that's not possible. They've all attained superannuation.
They have all attained superannuation, but they are not working in the ITCO itself.
No. So there's no question of any relief being now granted, sir.
Yes, exactly. That is what exactly I say, madam.
Then why should we entertain the present petition? Continue to entertain it.
But they are now pursuing that they should get everything as per the award itself. It's the Sangha who actually tried to move their grievances, madam, not individuals.
Who's representing them now?
The General Secretary, ITCO Shramik Sangha.
Who's representing them? Which is the lawyer representing them?
This lawyer was there last time he was there in the court. Since 2000, they are not working actually in the projects because projects have already closed. In 86, they filed batch of writ applications. Those writ applications were disposed of, saying that they are not going to be entertained and they can ventilate their grievances before the appropriate forum. So that is how the Sangha has now come forward and filed an application for reference, and reference was made to the Industrial Tribunal, though that was objected. Now the Industrial Tribunal adjudicated, confined from 80 to 43, out of the list they have given. And out of the 43, actually, they say those are the persons who should be allowed to be regularized. But they were not in service. They were not continuing in service. There is no continuity in service even. 90, they claim that they're 20 years of their service. 96. But they were reprinted through a lawyer, my lord. He was present last date, I remember. But I don't know why he's not there.
B. Satpathy was present.
Yes, Mr. Satpathy, my lord.
Ah.
You should hear it in his presence, actually. Otherwise, again, we will file an application for recall and all that.
No, we can pass it over, ask the registry to get in touch with Satpathy.
Yes,
Take it up at 2 o'clock, sir.
Yes, madam.
Take it up at 2. Just ask them to the minutes. This list is over. Then we'll come back after lunch. We'll come back after lunch.
Okay, pardon to mention one matter was argued before Lordship and Honorable Justice Patnaik. I have filed the written note argument with citation.
All right, sir. Thank you. Thank you.
Well, just one clarification, that is OA number 1036 of 2016 and OA number 1089 of 2016 disposed of on 16/5/2018.
Yes, that's what we have put down.
These two OA numbers have been given.
Yes,
to be reflected in the order.
That's a
Yes,
part of
it is.
that's a part of record, my lord. The intervener has filed the judgment.
All right.
Item 44. Sir.
This is
Mr. Liquid.
Who's this Mr.? Oh,
Mr. Satpathy was there.
he's apparently mobile is not reachable. So we'll just note that and post it for some other day.
Yes, madam.
Counsel appearing for the opposite party workmen, union, Shri Satpathy, is unable to be reached by the registry despite a passover. In the interest of justice, list on 12th April. In the meanwhile, the registry will once again try and inform Mr. Satpathy telephonically of the next date.
Grateful.
Right.
Special weekly list item number 38. Sir.
Please, ma'am.
Yes, please.
Okay, two applications had been filed, my lords, against the order of District Judge Cuttack. District Judge Cuttack, who, my lords, sets aside the order of the learned arbitrator on three amendments which were filed by the opposite party, my lords, during the course of cross-examination. And in fact, he files three. So one was allowed, one was deferred, not rejected, one was deferred. And the third one, my lords, was said he has no.
Now, who's for the other side, sir?
This brief has been actually going around.
Mr. Bidyadhar Mishra.
Probably my learned senior, Mr. Mishra, probably the brief has been transferred from him. That's what I could gather in the morning when I gave him a call, requesting him that I'll be praying for
The arbitrator will not deliver the final award, it says.
No.
The interim order,
My lords.
28th August 2009, it is open to the arbitrator to proceed with the case, but he shall not deliver the final award.
No, that is on, yes. It has not proceeded thereafter. It has not.
Virtually, then there's nothing.
Now,
how can this revive now after 12 years and 13 years?
No, now what has happened, my lords? Now, what has happened that the learned arbitrators possibly, that's the latest developers, possibly bedridden.
Anyway, I don't think so. This is all feasible anymore now.
So, another arbitration, if the other side is available, then we could. And
You
this-
say the challenge in the present petition was to an interim order of the arbitrator permitting amendments to the claim on
If it is,
20th August
Can
2009.
your lordship permit me one submission? If your lordship is thinking of another appointment, then
No, without the other side, there can't be an appointment. Whenever he approaches, the other side approaches, then you both get together and appoint another arbitrator. Otherwise, see, this is dead. The arbitrator is unwell. This is dead, meaning this case can't revive now. Nobody has that phenomenal memory to remember what happened some 13 years ago. All right. Just impossible. By sheer passage of time, some of these matters die. We can't pump back life into it. So it has to be a fresh de novo arbitration and only with the agreement of both parties.
these are definitely arbitrable disputes. The disputes are definitely arbitrable. That there's no doubt about that, my lord. But only thing is, your lordship is probably the entire issue is hamstrung because of the absence of the
other side
and the delay.
Correct.
So I would only, if your lordship just rolls it over by a week, we'll take.
No. You see, the interim order passed by this court on 20th August 2009 was to the effect that the arbitrator could proceed with the case, but would not deliver the final award without leave of the court. For over 12 years now, for nearly 12 and a half years now, that interim order is continued. Paragraph. None is appearing for the opposite party. although at one stage, Mr. Vidyadhar Mishra had entered appearance on their behalf. Full stop. Today, the fact Mr. Palit, learned counsel for the petitioner, informs the court that even the learned arbitrator is perhaps bedridden and is in no position to even continue the arbitral proceedings. Paragraph. Keeping in view all of the above factors, the court does not consider it appropriate to keep the present petition pending. Nevertheless, if the parties are able to agree on a fresh arbitral proceedings, they may appoint another arbitrator and have their disputes adjudicated.
Or we can approach the court under section 11.
Yeah.
Or appropriate.
By way of arbitration. If they are unable to agree on the name of a fresh arbitrator, they may take recourse to appropriate proceedings in accordance with law. The petition is disposed of in the above terms. A connected matter in view of the order passed in that
Same manner.
this is disposed of, right? In all matters, you say all pending applications are disposed of. So that again is listed for in that earlier matter which was mentioned, that service matter. You see pending applications are disposed of.
Weekly list, press admission item number 1, WPC 16355 of 2013.
None appears disposed for non-prosecution.
Weekly list item number 2.
None appears disposed for non-prosecution.
Weekly list item number 3.
My lord, no instruction, kindly dispose of.
All right. No instructions.
Weekly list item number 4.
Yes, my lord. Item number 4, the question is read at page number. Whether in the facts and circumstances.
Directed to grant 12 AA registration. So this must have already been granted in the last 4 years. No stay, no?
No stay.
Then why should we interfere? The present petition is directed by the department. The present appeal by the department is directed against an order dated 26th October 2017, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, in ITA number 317/CTK/2015, by the impugned order. The IT80 directed set aside the order of the CIT bracket exemption and declining to grant the opposite party, the respondent SSC, registration under section 12 AA of the Income Tax Act 1961 bracket Act, and the IT80 directed the CIT bracket exemption to grant such a registration. Paragraph. During the pendency of the present petition for over 3 years now, there is no stay of the impugned order of the IT80. In all probability, therefore, the order has been implemented. In that view of the matter, the court is not inclined to frame the questions of law as urged by the department in the present appeal. No substantial question of law arises. The appeal is dismissed.
Weekly list item 5.
My lord, the page number 6 question is there whether in the facts and circumstances case and in law the honorable IT is correct in remanding matter back to the field of the assessing officer to get the issue, ignoring the facts and the revenue has not accepted its decision in IT number 329 CTK 2013 letter 26507. My lord, this is the IT number 78 by 2017 has been disposed of on 2119 as called by circular. So review petition will file, which is pending with your lordship. So identical, there are 8 appeals which can be heard at together.
All right.
I given the review number.
So, but what about the tax effect? Tax effect here
is more than 1 crore.
I see. Okay, list along with
164 2018, 76 with 2018.
No, just show us the slip.
I'll give the list.
When is the review petition coming up?
On 212019.
No, review petition, when is it coming up?
It is pending.
No, when are you listing it, sir? Are you mentioning it for listing or?
In month of April.
Was it listed any time or not yet been listed?
Not listed.
Which was the bench which passed that order?
Honorable Chief Justice and Justice K.R. Mahapatra.
Oh, Justice Javeri.
Javeri.
Ah. You just say list along with all these appeals. Along with review petition number? So what's the number of the review petition?
261 of 2019. 261 of 2019.
261 of 2019, before a bench of which Justice K.R. Mahapatra is a member. On 25th March.
25th March.
25th March.
Weekly list item number 6.
None appears. Dismissal of prosecution.
Weekly list item number 7.
Your Lordship. The relocation and merger of a non-delivery sub-post office to GPO, General Post Office, Bakshi Bazar. Lordship, on the similar footing, Your Lordship, a judgment passed by this honorable court, which I have annexed it as Annex 4, Your Lordship. Annex 4, Your Lordship, at running page 66, Your Lordship.
So these are not matters where we should be interfering, sir. Whether a post office should be merged with another post office or not. These are not matters we want to interfere.
Lordship, may I pray the representation which has been filed by the petitioners may be considered.
All right. The petitioner's representation dated 29/12/2021.
24/12/2021.
29/12, right?
24.
Just come to page 53.
Page 53 are the representations filed by the elected members.
All right. 24/12/2021 shall be examined by the collector Cuttack. And after hearing the petitioners, a reasoned order shall be passed thereon. But the collector takes the decision or the postal authorities?
Lordship, there are several representatives of the postal authority, Lordship.
Then this 24/12 is to the
Director postal will take the decision.
Senior superintendent of post office. Then the other is chief postmaster general shall be examined with the chief postmaster general, Orissa Circle, Bhubaneswar. And after giving a hearing to the petitioners, a reasoned order shall be passed thereon not later than 20th June 2022. The order shall be made available to the petitioners not later than 27 June 2022. The court clarifies it is not expressed in the matter.
Weekly list item number 8.
Item number 8, there is some defect. It cannot be removed because the petitioner has taken the file. However, it can be disposed of in view of the decision of Paschim Bang Khet Mazdoor Samiti versus State of West Bengal and another 1996 4 SCC 37 Your Lords.
So these are all very broad sweeping reliefs, sir. It's of no use unless you get specific instances. This kind of a writ is of no use, sir. It won't be implemented. You see, the prayers are too broad and sweeping and not directed at any particular instance. Consequently, even if the court were to allow the prayers, there can be no effective implementation of such directions. Leaving it open to the petitioner to bring specific instances of violation of fundamental rights of the fundamental right to health before the court, the petition is disposed of.
Weekly list item number 9.
9, today I have filed a delay continuation petition. Today
That's okay, sir. tell us what the
21
matter is
days
about.
delay, Your Lordship, condone, then we'll proceed.
No, we have all condoned. Come on. What's the matter about?
Matter here, the question framed by the revenue in page 9, deferment payment. Here is a consultant's firm, he is not a contractor or a builder, to avail the work in progress system to recognition of the part payment and the paid the tax. Here the case is, see the finding of the tribunal on these issues.
What's the tax effect here?
Tax rate is more than crores of rupees. I'm just tax effect is 9 crore 29,74,660. Running page 38, first of all.
All right. What's the question now?
Question is not three question. One is deferment is allowed on percentage basis by the tribunal. Second one is whether the donation is deducted under section 37 of the Income Tax Act on the PL account. That is two issues. And the tribunal held that it is permissible in running page 26, paragraph 48 of the tribunal order. No, sorry, it is for a library. I'm just. Based on the internal page 15 of the tribunal paragraph 6, thereafter 7. Last part. After considering rival submission and perusing the material record, we find a learned could not point out any specific error in
No,
the
no,
order.
no, 1 minute. Internal page 15, 1-5.
Sorry.
Which page are you reading?
Internal page 15.
1-5.
1-5.
It starts with para 48.
Start from the tribunal order.
No, no, you're not reading the IT80's order.
Yes, I'm reading the IT order. Start from page 12, Annexure 1.
That's right. Yes. So, page 15 of the top page, not internal page then.
Yes, top page. Internal page is 15.
No, sir. Internal page must be 4.
Yes. Your Lordship, kindly brief fact is paragraph 4, running page 13. That my place first, then I will come to the finding. The brief fact of the case, the assessing officer observed that the gross receipts shown in income tax return and that shown in the service tax return was not the same. On being asked to explain the difference, and the assessor submitted that the service tax had not been paid in since financial 2-3-4, as there was confusion regarding nature of receipt and category in which it was to be considered whether the assessor received against the service provided as a management consultant. Cases 80% received in the financial 9-10 was diversion of the revenue to the next financial. The assessing officer observed the ledger account of the parties and the explainer claim under the different shade shows that they do not reflect party-wise detail of expenditure. He observed thus was not submitted that revenue recognition 20% of receipt was deferred to the next year because some work was still pending in the said project. It could not be reasonably submitted as to how that was determined 20% for all the project
in which the revenue recognition was deferred. Moreover, entries in the ledger account shows the payment is against the final bill, which indicate that the payment was not against an advance claim and it was unlikely that some work was still pending. This term of the contract indicate that bill had to be submitted on reaching some stage. The bank account ledger shows that payment received will before the year end, and therefore, even if some work was pending when the service fees was received, it could not be held good for the year end also. Taking into fact and consider the assessment held that was reasonably to not to accept the submission of the assessee regarding revenue recognition 20% of it receipts in the financial 10-11 and added a say receipt of 13 so and so in the income of the assessee.
What's wrong with this?
Because here it is not a work in progress system work. It is not accepted that accounting standard AS 17. This is applicable to the builders and the promoter of the land leasing business. Here he is receiving after completion of the work, he has received the amount of management work and he has not seen in advance. Therefore, the accounting procedure maintained is not perfect. Therefore, the IO has disallowed the same. But the tribunal has come to a conclusion.
No, because there was earlier years, CITA has held that the SSC has in earlier years deferred income.
13 crore and 17 crores. In running, start from paragraph 7, I'm placing internal 15.
Yes.
After considering the rival submission and perusing the material record, we find that learned DR could not point out any specific error in the order of the CIT appeal. CIT appeal was allowed in favor of the assessor. We find that the CIT appeal has held the assessed in the earlier deferred income of 17 crores, which had been assessed by the assessing officer. There is no reason for him to deny the deferment for the year 13 crores. Thus, if the assessing officer does not allow the deferred income 13 crores on this year, simultaneously should not tax deferred income earlier 17 crores. We are of the considered view that SCC has been following this method showing incomplete service projects for a long period of time. It is revenue natural and hence cause no loss of revenue to the department. Hence, we uphold the finding of the CIT dismiss the ground appeal of revenue.
We're not able to understand what's wrong with this.
The wrong is not.
You've allowed it earlier.
No, he is allowing the earlier 17 crores, but your lordship know every assessment is different.
There's no loss to the revenue, please.
No, but
whichever year it is, you're going to pay tax in that year.
Then he has used that money, not paid that year. That accrued interest even.
That's how the accounting principle itself is.
But this account is not for this type of business people. Your lordship know that.
You say, which is the other question?
Other question is that it start from whether the payment made as a donation and claim that is a advertisement expenses to the golf club and the it start from one is golf club, another is renovation of the library of CIA, Institute of Chartered Account of India Hall. Yes, expenses 9 crore 15 and paid to the golf club 2 crores amount rupees 2,50,000. 2,50,000 is 22. That has been treated as advertising expenses, but actually is paid donation as per the ledger. This make out a case that it is a advertising expenses, but actually it is a donation.
Yes.
CIT appeal disallowed the same, but tribunal allowed that because some people are going there and viewing your.
It's all possible view to take place. This is the department's appeal against an order dated 16 July 2017 passed by the ITAT Cuttack Bench Cuttack in ITA number 504/CTK/2013 for the assessment year bracket EY 2010-11. This appeal has not yet been admitted. The two questions sought to be urged by the revenue are A and
D.
C.
C and D.
Okay, A, C, and D. Having heard Mr. Satpathy, learned counsel appearing for the revenue, and having perused the impugned order of the IT-80, the court is of the view that none of the above questions can be considered to be substantial questions of law, warranting interference by the court. As noted by the IT-80, the treatment of deferred income is merely being consistent with the past practice involving the same SSC. As regards the other two questions, the view taken by the IT-80 is a perfectly plausible one. And merely because another view is possible, no substantial question of law arises. For all of the aforementioned reasons, the appeal is dismissed.
Delay may be
Delay is granted.
Weekly list item number 10.
Pleasure, Lords. 9 or 10?
Item 10, ICA 9 of 2018.
10. At page 3, the Supreme Court of India has dismissed the appeal of the petitioner. The judgment is there, and your lordship has also passed similar order on 11/3/2022 in the case of Orissa State Police Housing Board Welfare Corporation. The notice to be issued to the opposite by register post with the ID written over. The question is the same, whether in the facts and circumstances.
All right, just all right.
Para 5.
Same one. Same.
Weekly list item 11.
But in this case, there is delay of 104 days. Pray, my lord, I will take steps for limitation.
Where is the delay condition?
My lord, I have not taken this file. Week time be allowed. My
No,
lord.
no. Where's the question? You say admittedly the present appeal is delayed, but it's not accompanied by any application for condemnation of delay.
On merit, your lordship.
How many days delay?
104 days. 104. Delay of 104 days.
There's no explanation, therefore, for the inordinate delay of 104 days in filing the appeal. The appeal is dismissed on the ground of limitation. Nevertheless, the questions of law are left open for consideration in some other appropriate case.
Weekly list item 12.
Below 50 lakhs, covered by circular.
Covered by?
Covered by circular, 1 crore.
You say council, revenue states that this is, the tax effect is below the monetary limit.
Monetary limit.
Dismissed is withdrawn.
Weekly list item 13.
May I please, my lord?
Yes.
My lord, in this case, the petitioner challenges the issuance of notice under section 148, which has been issued beyond the limitation period, that is 6 years from the end of the assessment year 1340. And the notice has been issued on 30th of March 2021, which is more than 6 years. And the opposite party has filed counter. They have relied upon the notification of the extension of time limit, that is to the tax and other.
It is pending. Lordship had here is question is 1314 is ended on 31st/3/2020. Before that, the notification has extended that limitation. Therefore, Lordship was because a permission has given the PCIT Bhubaneswar 1. Your Lordship disposed the matter where the permission was not granted by the PCIT.
Because 30th March is not covered by the.
Yes, Your Lordship, that is covered. Your
And
Lordship,
this
see
aspect which my learned friend is trying to contest, my lord, has already been covered by your lordship's order in Ambika Iron.
Correct.
Where I'll just place one paragraph from that judgment, my lords.
Yes.
The stand of the revenue that in view of the notifications issued by the central government in terms of the provisions of the taxation and other laws, relaxation and amendment of certain provisions Act 2020, and the said limit stood extended is clearly untenable, as those notifications were issued to deal with the situation arising from the amendment of the IT Act by the Finance Act 2021 with effect from 1st of April 2021.
Correct.
Whereas in these cases, the notices were issued prior to 1st April 2021.
Correct.
So this is something akin to item number 34, which is now item 34 in your lordship's list, my lord.
Right.
And if your lordship would permit me.
No, this order, can you give it to us?
May I just, I'm sorry for interrupting your lordship. Ambika order, my lord, which I was referring, your lordship may kindly turn to paragraph 4, my lord.
No, that's right. So I know.
Your Lordship, only can I record
And your lordship would appreciate the other judgment which your lordship has disposed of. Your lordship may permit me, my lord, Biswajit Karmakar, may I just please that ordinance. It's a short order where.
Karmakar, Your Lordship, correction of the order.
Review for what?
For modification of the order.
Because, my lord, kindly hear me for 1 second.
No, not 1 second, sir. We'll hear you for 1 hour.
Here is a case, in this case, what my senior is placing, so far as the judgment of this.
Karmakar, Biswajit Karmakar.
No, that the.
Ambika Street. Ambika,
Street
your lordships have dealt with that extension, where your lordships have held specifically that it will not be applicable to those notices prior to 1/4.
Let him answer that.
This notification allowed the department to extend it with effect from 1/13/2020. Thereafter extended for July.
No, but only from 1/4, sir. This is
No. This notice is retrospectively not given. Your Lordship, I think, Lord, I am not placed properly on that, because I am not arguing this case. Your Lordship, see the notification. Section 3. Section 3 of the Act.
Here, your lordship would appreciate that as per the old act, if it is beyond 6 years, even if it is sanctioned by the principal commissioner, that is not going to save the limitation notes. Because your lordship would appreciate that now 148, it was either 4 years or 6 years.
Correct.
With the introduction of 148A, my lord, it was 3 years and 10 years. So even if the principal commissioner does it, it can't be said
anyway beyond 6 years.
It can't be beyond 6 years. And this extension was very much decided in Ambika, where a batch of writ petitions were disposed of by your lordships.
Correct. In the present case.
Kindly,
your
Lordship, see the act of the relaxation of the act which has been passed by the Parliament. There, your Lordship, see paragraph 3, subsection 1.
So we are not referring this again to a larger bench now.
Because that has not been, if I say, Lord, that has not been considered while passing this.
Whatever.
My lord, another fact I would like to bring to you, my lord, attention. The amended section 149, that is the proviso. My kindly be looking. The amended section 149, that is time limit. That is a proviso. That proviso says, provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or before first day of April 2021, if such notice could not have been issued at that time, on account of being beyond the time limit prescribed under the provision of the clause B of section 1 of this section, as they stood immediately before the commencement of Finance Act 2021. So the amendment of time limit, they specifically provide that you cannot give if it is already time bound.
That his notice prior to 1/4/21. His notice on 33/2021. Sir, how can you
Yes.
place that amendment provision here?
They say if it is, if the time limit is expired before that day for that assessment year, the provision may kind be read again. The amended provision for time limit for notice 149, the provision may be ready to. So if the provision will read, it clearly says those notices cannot be issued. Even if
With great respect to Mr. Mahanti, that may not be very much relevant, my lord, in view of your lordship's two orders, my lord, disposing of batch of writ petitions.
That's only my submission is that the relevant provision, Lord, it's not been section 3 of the relaxation of the certain provision of the specific act which was passed by the parliament has not taken into consideration while passing this ordinance.
No, we've quoted that whole thing.
No, my lord, I'm sorry, my lord, but that because they say
Paragraph
where any
4.
time limit has been specified in or prescribed or notified under the specified act which falls during the period from 20th day of March 2020 to the first day of December 2020 or such other date after 31st day of December 20, as the central may notify, specify in this behalf for the completion of the compliance of such action as under. Not there says Lord, and subsequently the revenue distributed as notified and extended one after another. In Lord July, it was extended till July.
Your lordship,
therefore, that part has not been. Lord, it was on virtual mode. So I think Lord,
your lordship may kindly mark the word 30th of March 2020 to December 2020, my lord.
Yes.
So these are cases where these notices, the 6 years limitation, my lord, expires on 30th of March 2020, my lords. So if it is beyond 30th of March 2020, even what my learned friend Mr. Satrapati is placing, my lord, that will not be saved. Correct. That is why your lordship specifically in Ambika at paragraph 4.
The challenge in the present petition is to notice under section 148 of the
Lordship may
Income
also
Tax
take
Act
care of item
91,
numbers
bracket 8 Act, which is dated 30th March 2021, which is more than 6 years after the expiry of the assessment year 2013-14. In similar circumstances, in its order dated 24 January 2022, in Red Petition Civil 20919 of 2021, bracket Messrs. Ambika Iron and Steel Private Limited versus Principal Commissioner of Income Tax, bracket. This court has quashed the notifications in similar circumstances, identical notifications under section 148 of the Act. Paragraph in that view of the matter, the impugn notice and all consequent steps taken thereafter hereby stand quashed. The writ petition is disposed of.
Similar orders in item number 34.
34, 35, 36. Item number 34, 35, 36.
In view of the order passed today in 720 of 2022, the impugn notices and all proceedings consequent thereto challenged in the present petition are hereby quashed.
Now, then, so far as 34 is concerned, your lordships, your order will take care of WPC 4645 of 2022. That's a 7th item, sub-item, my lord, in item number 34.
And item 34?
Item 34, my lord. There's a whole batch, my lord.
Give us the writ petition number.
4645 of 2022, Ashok Khemka.
Alok.
Sorry, Alok Khemka, I'm sorry.
In view of the order
So this is 1314. Then your lordship would, the second item, 4649 of 2022, Mirza will also be covered, my lords.
All right. Both these.
And also 5360 of 2022, Bhavani.
All these three, you say in view of the order passed today. In the petition so and so.
The 3 cases I am happy.
The impugn notices are hereby quashed.
Item number.
So the same order may be repeated.
Sorry?
The same order may be repeated in these 3 cases.
All right.
Greatly obliged.
All right.
Obliged.
What about the remaining matters?
Milords, in item 34, Milord, writ in 20.
Correct.
These are the matters which already stood covered by your lordship's order of Ambika. So your lordship segregated those matters out of that list and listed it for today.
Your Lordship, I have also two matters.
Yes.
There are also two matters, Your Lordship, 36539 of 21. And another is Your Lordship,
He says it is within time, 36539.
36539 was issued by with the prior permission of JCIT, Your Lordship.
You said within 4 years.
But JCIT, it has to go anyway.
No, Your Lordship, that is my point.
That is prior to my lord 31st of 21, my lord.
Correct, but issued by the JCIT.
And by that time, the new act, my lord, had not come. For that, my lord, it will be treated in the in view of the old act, my lord, where JCIT.
In the old act also JCIT was not permitted.
If it is within 4 years, then JCIT. If it is beyond 4 years, my lord, it can't be JCIT, my lord. Ambika Steel also
beyond
takes
4 years.
Beyond 4 years.
So
Yes,
it takes Ambika Steel also, my lord, your lordship, in my case.
That is within 4 years, my lord. The lordship, in this case, the
That matter
year
is-
1617. Notice issued on 31st March 2021.
Thank you.
For that, it is listed alone.
Prior, that is my point.
No,
With
so
prior-
it's
prior
not beyond 4 years.
Lordship 1649 of 2020.
You can't in between, please. We are dealing with some matter. How can you suddenly button like this, please? I think we've already dealt with your matter. Why are you again and again mentioning matters which have already finished? Please don't again and again mention. You'll unnecessarily add to confusion, please.
Sorry.
Yes. I'm sorry, Your Lordship. It will go. I'm withdrawing that.
You say this 36539 constitutes the petitioner seek so this is covered.
Another also I have given memo, Your Lordship. That
No, but this is dated 8.
Date is, my lord,
2021.
9th April 2021. By that time, my lord, the 31st March 2020, 6 years were had completed.
Right. All right. This 35607, in view of the judgment in Ambika Steel, the impugn notice is quashed. The writ petition is allowed. No costs.
another matter is 96729 of 2022. Financial year 13-14.
Copy.
It's not in the list.
It
is not in the list.
I have mentioned today morning. I have given the memo. Mr. Chimanka is appearing in that matter. 13-14. 6729. Yes. 6729 of 2022.
We will take it on board. It's not listed. We'll take it on board. This taken on board. In view of the judgment in Ambika Steel. The impugn notice is quashed. All right.
May I please, my lord? My lord, item WPC number 36990 of 21. In case of Ravi Metals Limited, item number 30 was the same, 6 more than 6 years, assessment at 32.
First one. Same order in the first one.
My lord, under item 34, that 38320 of 2021, that is also beyond 6 years. That's
All right. 38320. Same order.
With your lordship's kind leave, there are two other matters, my lords, which we have filed identical issue, my lords.
Unless you serve copies, they
I
won't
have
know.
served copies. I have served copies on my
Not in
lords.
the list, for that I am unable, my lord. Lordship may list it tomorrow so that I can take.
You mention it in the morning tomorrow then. By then you would have seen it.
My lords,
Yeah.
I'll do that. I'm grateful.
My lord, 1167 of 2022 is covered, 6 years.
Sir, you've already.
Four proceedings.
Yes.
We are grateful, my lords. We are grateful.
Yeah, all right.
I may be pardon you, lords, that matter what I prayed for withdrawing, that may come on 11 July, let's say, because this is beyond 3 years and new act has been challenged in this. So let it come on 11 July, let's say.
All right.
So let it come on July, so.
That may not be covered, my lord, because all these matters, my lord, that falls within the.
Anyway, it's challenged. The Allahabad High
Yes,
Court,
yes.
that challenge is there. So it will depend on what happens in the Supreme Court.
No, that is, my lord, that is pertaining to, my lord, 31st March 2022, 31st March 2021. But here, by 31st March 2021, by that time, the new act had not come. His case is, my lord, within the time limit, so that the notice issued.
Actually, what is coming on 11 July is at 148 AA.
Yes, ma'am.
It has nothing to do with this. It's better it's withdrawn only. Just stick to the
Yes,
same
yes,
order.
yes.
Right.
35 and 36.
List item number 14.
Item 14, my lord, cover matter. NOC petitioner brought NOC state Uttarakhand to submitting state Orissa from
Yes, my lord.
Bhubaneswar. It is the covered matter.
Yes, my lord, that is covered, my lord. Similar order in other cases.
All right. Same order. Where is the order? Yeah. Same order. All right.
Weekly list item 15.
Is the transfer of the OA plot.
Nothing survives. All right.
Weekly list item number 16. May it please. We have obtained the necessary instructions with the communications which HPCL had made with the Lord, on the last occasion, Your Lordship, recollect, this matter relates to the.
So it's not been renewed after, you not exercise your right to renew after 31st October.
Lord, we have. Lordship takes this compilation which I've handed over today. Annexure A are the letters, my Lord, 2011, 2 letters, 12, 13.
No, but after, sir.
After is Annexure B, my Lord.
What?
10 to 2014, we made a request. And my Lord, I have ascertained on obtaining instructions, I was told that repeated negotiations had been going on. And each time on the financial aspect only, they are yet to revert. And my Lord, release rental is paid till February 2022 and accepted. Lordship sees page 12 for a moment. Page 12 of this compilation. That is after the.
No, and what about market rent?
My Lord, the market rent, my Lord, unfortunately, my Lord, the lease rental is being paid in terms of the lease deed as in the
So it
past.
doesn't satisfy that market rent requirement.
It does not.
Ah,
But in fact, at page 6, I have taken specific instructions. What is the rate? My lord, I shy away from making that submission, my lord. Paragraph 8. Lordship sees the amount, my lord.
350 rupees. That's
355 rupees per month is being paid, my lord.
So you best give us a time limit within which you will vacate. That's the best thing.
My lord, my humble submission before Lordship would be, my lord, if your Lordship permits the negotiation to go on, my lord, because I'm told only the part of the rent is where it is getting stuck.
So suppose you were to pay the market rent from the date you are supposed to pay.
My lord, I have obtained instructions, my lord, as on today. If the market rent is to be taken, my lord, it would come to about 18 to 20,000 rupees a month in this area. And HPCL is willing to pay that.
No. So why don't you first make that payment and then we can talk of negotiation?
Well, up to 22 February, as in last month, they have received the rent at this rate, unfortunately.
No, they may have received, but the Supreme Court judgment requires you to pay market rent.
Well, in those cases, the party had not received the rent. Well, here is a case. Lordship marks at page 10 of the writ petition, he discloses that he had approached this honorable court, my lord, and thereafter withdrew the writ petition for the same period for negotiation. ₹18,000.
You have to unmute, Mr. Jena. You have to unmute, sir. Mr. Jena.
You're not audible. Unmute your system, Mr. Jena.
Lordship marks, even in Dolly Das,
Don't unless we hear Mr. Jena, I don't know how we can. He's not able to hear us. I think. Renew the connection. Refresh it.
judgment, you know, I've got that also, this national company. Arose from this honorable court.
No, I think national company, one of them said national company.
No, national company said, my lord, that the market rent would be determined in terms of the data being submitted. That's the last part of the judgment.
Correct. Keeps on talking. You can't hear us. Mr. Jena, you are not audible.
Reconnect again. You are not audible, Mr. Jena. There's some problem at your end.
Probably we can have it tomorrow.
Yeah. No, we'll make it conditional. You say a written note has been submitted by Mr. Aditya Das, appearing for HPCL, as regards the HPCL expressing its willingness to continue the lease beyond 31st October 2013, he produces a letter dated 10th February 2014 addressed to as regards the payment of market rent. He frankly states that HPCL has been paying, and the regulars have been accepting the rent and Supreme Court dated 11th November 2021 in Civil Appeal number 6726 of 2021. HPCL is expected to pay the market rent
That judgment
from
is
1st November 2013 at least.
That judgment is already reported. I've got the citation also.
Yeah. Consequently, the court directs that the present market rent of rupees 15,000.
15,000 is reasonable.
No.
I leave it to your lordship. That is the prevalent rent there.
No. Where is this petrol pump?
Milord, Aintapalli, Sambalpur.
It will be only that much. It will be much more.
In area.
Huh?
Posh locality of Sambalpur.
It's a posh locality, is this?
No, when I saw the amount which was being paid, Milord, I was very disturbed person.
You see, the court tentatively fixes the rate to be paid at rupees 20,000 per month from 1st November 2013 onwards, and the amounts till date, and the amount so calculated will be brought to this court by way of a demand draft in favor of the petitioner on the next date, to be handed over to counsel for the petitioner. The court will, subject to compliance with this direction, the court will be willing to consider sending the parties for negotiation. It is made clear that the above amount, payment of the above amount, is without prejudice to the rights of the petitioners. List on 5th May.
I'm obliged, deeply obliged.
All right.
And I'll ensure it is done.
Weekly list item number 17.
Well, item number 17, I have no instruction regarding in this matter.
All right. Petitioner says he has no instruction. Dismissed.
Weekly list item 18.
Or item number 18, my senior Kirut Kumar Raut is having some personal difficulties.
No, tell us what the matter is.
1 week time.
No. Tell us what the matter is. We'll just see what the matter is.
Sorry? That's it.
Sorry? She's not? No. In this petition filed way back in 2013, notice is issued on 27 January 2014. After which there's been no effective order whatsoever. So stop. Without accounting for any developments that have taken place in the meanwhile, it will not be possible for the court to pass any effective orders permitting the petitioner to file a fresh petition if the cause of action so survives. The petition is disposed of.
Weekly list item number 19.
None appears dismissed for non-possession.
Weekly list item number 20.
I am for the opposite party.
Right.
19 infructuous.
Weekly list item 20.
None appears.
Weekly list item number 21.
None appears dismissed for non-possession.
Weekly list item number 22.
My lord, item 22, 23, 24, and 25 in process.
Infractuous, all right.
Weekly list item 26.
None appears dismissal. No.
Weekly list item number 27.
None appears dismissal. No prosecution.
No, may I play, in this case, I have been engaged as amicus curiae to assist your lordship.
All right.
But this is a case relates to the death of the people while faring in various places of the state. The PIL was registered by this honorable court for that reason. Because there is no act or rule so far as the registration of the boats or anything in this state. Whatever I have found out from the various state rules also, there are some rules of the Bengal Act which is of 85. There is Tamil Nadu Canals and Public Ferries Act 1890. Government of Odisha, there is a draft rule of 2004. I have filed the documents today, but there is no safeguard provided for a man who dies on the boat or due to the drowning in the boat. There is no, the vehicles, the boats are never registered, or there is no insurance coverage. Nothing is there. So the man who dies, he dies like that. And there are various.
Where is your compilation, sir?
But I have given today, I have sent it to your lordship's bench today. The various acts of the different.
Oh, I see. All right. Mr. Shaktidhar Das has placed before the court the draft Orissa boat rules of 2004 and points out that till date there is no legislation to provide for remedies for those suffering as a result of the mishaps occurring due to plying of boats in Orissa. Stop. He has placed problem of people but here
I will give it by evening.
you got a copy. File a detailed what are the statistics?
Minutes, I have not given any statistics, minutes, but I have only noted down there are recent incidents in Machkund, then Indravati.
I'll prepare a note. Provide a copy thereof to Mr. Katia.
Oblige.
List on, we'll have it after the opening.
Yes.
6 July. 6 July.
Oblige. Obliged. Yes, I am obliged.
That the issues doesn't survive much, but just tell your lordships. It was on basis of an income tax rate. I had come to your lordship. I'm a doctor. I had come to your lordships. Tribunals and other things have passed orders. Only one survives. They are enough protected. 40 lakhs is still with them. So nothing survives on this petition,
right.
which will be abide by the final orders
All
passed
right.
by an assessment.
Mr. Padi, learned senior counsel. Tax Appellate Tribunal. Accordingly, the present petition is not pressed any further. It is disposed of as such.
I am appealing this.
All right. All right.
Great.
Quick list item 31.
Circumstance of the case in law, the tribunal is justified holding that a proviso to section 201 on. And second one is second responsible to oblige, and the JB and further when the JB are responsible to oblige the RVL and contractee, and decision of the tribunal holding that the JB has not responded deducting TD. Order of the tribunal.
There are so many assessment years. You've filed only one.
Confined to only 11 and 12. ITA number
25.
ITA number 15. ITSSA number 15. CTK 2014. 11, 12. And there is a soft. Question that I have checked off not file, that I have not reserved the file. Earlier, this court directed me to know whether the case of UNA Raju construction of passed by the Visakhapatnam International Tribunal is reached finality or not. I have issued a letter to the Hyderabad, but I have not yet received any communication whether that is reached finality or not. There, the case was allowed in favor of the assessee because of the retrospective effect and the deduction of TDS. Whether JV1 is issuing deduct paid and whether tax deducted by them or not.
Or did you find out? You say the counsel to the appellant revenue states that he's awaiting instructions on the outcome of
UN Raju construction passed by the Visakhapatnam Income Tax Tribunal.
No. What's the total? What's the cost? Is this CIT versus UN Raju or?
At least not.
And this UN Raju is not related to this person.
No, it is not. But similar issue has been considered by the Visakhapatnam Tribunal. I-88.
The outcome of a case of UN Raju.
Yes.
ITA number?
That is not with me.
How are you going to find out if you don't have the number? Where are you getting all this?
Your Lordship, 5 to 20. Lord, your order on 5 to 2020.
5 to?
5 to 2020. Order was passed by the Honorable Court. That is reflected in the order.
No, it simply says enable him to take instruction.
Let's kindly keep it next week. I will.
All right, Mr. Satpathy needs some more time for instructions on a similar matter pending in the ITAT Hyderabad. Must be.
ITAT passed by Visakhapatnam Income Tax Tribunal.
Is there an ITAT in Visakhapatnam?
I have taken on
There is it? There is one in Visakhapatnam.
There are more bunches have been constituted in the ITT.
Ah, okay, Visakhapatnam. List on 11 July.
Weekly list item 32.
32, my lord. Here, my lord, Arjun earlier on the ground that similar appeal, whether the department is filed appeal on the same cause of action where the tribunal has passed against the revenue.
Here again, you'll have a problem. This Neelachal Ispat has been taken over, I think.
Yes, taken over by the Tata. My senior is appearing.
Tata Steel long products.
Yes.
That should be right.
They have to be brought on record, I think.
Yes, Lord. There are 7 matters.
If the shareholders agreement is over, the formal takeover will happen shortly.
All right. So we'll then postpone
Go
it.
ahead with this. Either your lordships call it after a week, 10 days, or
I think we'll call it afterwards.
Fair enough.
Since the respondent is in the process of being formally taken over by Tata Long Products
Tata
Limited.
Steel Long Products.
Tata Steel Long Products Limited. List on 30th June. 30 June.
Item 33.
My lords, the Union of India has taken time to file countermeasures.
Mr. Pari, you there?
Yes, my lord.
What happened counter?
That PL matter.
Item 33, yes, that PL.
Last
That is Nilachal is for this additional matter, my lord.
Yes.
In that case, we have reduced the counter. We are filing today or tomorrow, just to do a short correction.
Mr.
Today,
Pari
just
assures
now
the
it's-
court that the counter will be filed in 3 days. Rejoinder before the next date. What about opposite party number 5?
My lord, I have filed it. I have filed.
All right.
OMC also a party. MMDC also party.
Lord, my lord, may I come in for a moment? In this case, notice has not been issued till date, my lord.
Yes, yes.
All right. Just a notice. Mr. Das accepts notice and states that he has already filed
On behalf of
counter affidavit on behalf of opposite party number.
No.
We are for OP number 1, 2, and 10. Others are the OMC is
Mr.
OP
Pari
number
accepts
9.
notice for 1, 2, and 10.
OMC
States
is
that he will be filing his reply within
Mr.
3
Mudli
days.
takes notice for 9.
Mr. Mudli accepts notice for 9. And states that he too will file his reply before the next date, within 4 weeks. Rejoinder, if any, be filed before the next date.
State is opposite partner 3 and 4.
When do you want it, Mr. Mahapatra?
My lords, any 2 weeks after, 3 weeks after, whatever my lords may fix my lords.
Last may
28
fix after 4 weeks. Better.
28 June. All right.
28 June, my lords. My lords, fixing it 28 June, my lords.
28 June.
Little bit earlier, my lords. In the month of April, last week of April, we'll do, my lords.
All right. Then we'll have it in May. 10th May.
Problem.
Copy of the
10th May, my lord.
along with the annex.
I'll sort copy.
Weekly list item number 37.
37, may I please, your lordship?
36 disposed of.
Over, sir.
34, 35, 36. Item 37.
37, my lord, I may be permitted to place my case. My lord, this is a PIL. Your lordship may kindly come to page 14, annex 1. Page 14, my lord. My lord, here, your lordship may kindly see different photographs. A Odia film has been released here in the
I asked you to find out about the censorship. What happened to that? Is this
My lord.
film still running?
My lord, still running. Still learning. Your Lordship directed the Learning State Council to take instruction.
Both petitioner was directed to produce the censor certificate.
My lord, I was also directed. I have also, my lord, did my duty properly, my lord. I filed application, but they are not providing me. This is the application with me, my lord. Instantly, my lord, I have filed. Under which circumstances and what are the criteria that must be given to me, but that was not provided. I have given instantly.
This is such a successful film, is it, Mr. Mantri?
I don't know.
It seems to have one of the longest running
It is a
films.
Odia film. I have not seen it.
It's so successful, is it, Mr. Samantray?
My lord, yeah. My lord, usually
If it is so successful, then nobody's having a problem.
No, my lord, no successive, my lord. It has not been successful because from various points
If
of
it is not successful, why are you bothered?
Actually, I do not know whether there is a cinema like Mr. Kannaiya, where it was.
Lord, various peoples are raising.
Are you indirectly? Are you trying to give the film a publicity?
No, my lord, I am
otherwise not running.
My lord, not entire film, my lord. Those scenes, obscene scenes are there.
No. Nobody has heard of this film.
My lord, everybody has heard.
You seem to be the only one who's so bothered about this film.
My lord, we usually we don't have any time to see all those films, my lord.
No. If you don't have, then you should just leave it be.
My lord, throughout Orissa, my lord, your lordship may kindly visualize small children.
No, I can't visualize. This is the difficulty.
My lord, here our Lord Krishna is dancing with cheer girls and wine bottles, my lord. That hurts our sentiments, my lord. We being the Hindus, my lord.
No. See, again, all of this has to be put in context. If somebody is not watching anything at all, nobody's even bothered about it.
My lord, we are bothering. My lord, we are admitting that we don't have any such valuable time to see films, my lord. But those are, my lord, acquainted with the films, my lord. In our age, my lord,
there are so many things around us which can be objectionable. All right.
My lord.
If it has the propensity, suppose let's say it's hugely successful, then it has a propensity of having a deleterious effect in the way you are trying to apprehend.
My lord.
But if nobody is bothered about it, they're ignoring it. Why are you raking it up?
My lord, your lordship may kindly see every day, my lord, halas are being raised by.
No, I think I'm seriously going to ask. Just find out how many cinema halls is this running? How many cinema halls is it being screened?
My lord, that is at Cuttack and Bhubaneswar, major cities, my lord. Number of people are residing here, major city, my lord. Here in both cinema halls, it has been
How
released.
many cinema halls is this film being screened, please? And since how long?
I think it is not yet. It is only in wave channel.
No, it has been released.
It has been released.
When was it released and how many cinema halls has it been released?
My lord, it has been released since, my lord, I'm saying, my lord.
These type of films, your lordship may kindly
4 to 2020.
only for 1 week it will survive, then
that's
it is close. Maximum 1 week.
Yeah. In these age and times, no film runs for more than a week.
My lord, if this time, my lord, action will not be taken many times, my lord, this type of film will again be recasted.
No. You first find out if this film is still running or not.
My lord, still running since 4 to 2020.
No. Tell me how many cinema halls is it running?
My lord, that I will say. That I will say.
At the request of counsel, the petitioner list on 9th
next
May.
week.
Yeah.
9th May, my lord.
Sir.
My lord, till then, my lord, this film must have
Nothing will
been.
happen, sir. Nothing has happened. Nothing will happen. Right.
My lord, long days, my lord. Only 15 days time. I will just within 7 days.
You
my lord,
also have to get the censor certificate, sir. All right.
Wiki list item number 38.
May I please your lordship? Oh, sorry, my lord. Next. I'm 39.
Yes, sir. Yes, Mr. Mukherjee.
I'm in 39.
Yes. 38.
ITA 87 of 2009.
Yes, good.
ITA 87, sir.
Well, yes. Your lordship may take paragraph 8 of page 26 in your order. Here, your lordships will find that the tribunal has recorded a finding. May I place it, my lords?
Yes.
And of hearing the rival submissions and careful perusal of the materials available on record, keeping in view the fact that though the SSCs have incurred genuinely the expenditure in respect of the Bhubaneswar slum areas, in accordance with the memorandum of understanding with the different foreign donors, but the same was not in accordance with the objects of the trust. However, in respect of expenditure incurred on account of the Karanjia project, we are of the considered view that they are covered by the objects of the trust. And on this account only, without rejecting my books of accounts, he has gone on to make an assessment under section 144, which is not permissible in law, my lords. I am a registered trust, and I ought to be assessed under section 11 to 13 of the Act. My lord, I am bound by what the foreign donors who are contributing MOU with the foreign donors. They provide the manner and the way I am to apply the donation amount. Now that is accepted. Now, after that is accepted, how can they say that we accept it in respect of Karanjia, but we don't accept it in respect of Bhubaneswar? Can they, my lords, reject my books of accounts in this manner, my lords? And without a piecemeal, my lords? And without rejecting the books of accounts, can they make an assessment, my lords? That is the short question which falls for your lordship.
Yes, Mr. Chimanka. How do you accept it for one and reject it for the other? If they are spending it for tribal welfare.
The CIT appeal is in para 6 is, I confirm the order, action of the AO in making page 20.
No, it's concurrent. Even in the ITAT, they've agreed with the CIT and AO. The point he's asking is, you accepted it for one set of expenditures in Karanjia project, but when it comes to Bhubaneswar slums, you're saying no. What's the rationale behind it?
Was not applied for charitable purpose, being 50% of the expenditure booked.
So on what basis? Is it simply rule of thumb that 50% I won't allow?
Because for the given breakup of 40, page 25, program expenses, support staff salary, project operating and other administrative expenses. Has not put a single voucher.
No. So
is not produced a single voucher for the authority.
No, but how do you allow 50% then? See, once you accept it's a charitable trust.
Well, that's page 25, parasip. At the time of hearing before the Lebanese Council appearing for the SSC has condemned the AO or the Lebanese CIT was not disputed a single voucher or the supporting thereof. But all the expenditure are supported with the authority voucher and most of the payment are made by account pay check. Moreover, such expenditure are part of the ongoing project of restricted grant of foreign donor incurrence subject to the donor's budget. And accordingly, since they has not produced the documents regarding the page 26(7). On the other hand, learned DR appearing on behalf of the revenue has heavily relied on the order of the assessing officer and pointed out the expenditure incurred by the SSC trust is not accordance with the object of the trust. Therefore, the SSC is not entitled to the expenditure incurred against this account. However, the AO has disallowed only 50% of the expenditure. Hence, he supported the order of the AO in disallowance of 50% of the expenditure for Bhubaneswar slum area as well as Karanjia project. Therefore, requested to uphold the action. Page 26.
No, he submitted vouchers and other documents. That's
what not for charitable purposes.
No, para 6 it says he did submit the vouchers and other documents.
Then the assessment page 16 also. Then another argument that was put forward by the SSC was that the expenditure on Bhubaneswar hence not acceptable. Tribal development for Bhubaneswar slum actually includes the expenses on the staff of other region also. This is a clear contradiction of what the SSC has been claiming earlier, that the money was spent and hence categorized for rural and tribal development in Bhubaneswar slum area and hence not acceptable. Page 16, paragraph 6.
That is my submission.
16 is the assessment order.
Yes, assessment order.
And in my additional grounds affidavit, I have given that on identical facts for the assessment years 2007, 8, 8, 9, 9, 10, my plea has been accepted by the tribunal.
Oh, I see. And this is which year, AY?
This is 4, 5, 5, 6. This is 5,
So for the
6.
subsequent AYs, he has accepted it.
Yes, accepted. And I've got the reference.
Then let me take instruction with the subsequent year, whether the.
I've given that in the additional grounds. I've served a copy of this on Mr. Satpathy.
No, it's not with me.
Mr. Satpathy has received it.
No, I served the copy of the IT appeal.
And the grounds.
And the grounds, additional grounds. I've got a receipt, acknowledging receipt of both.
Yes. The tribunal order, not the subsequent assessment year.
You see, this is an appeal with the SSC against an order dated.
But for subsequent year, there is a demand. And annexure 5, page 8.
12 June 2009, passed by the Income Tax Appellate Tribunal. Cuttack Bench, Cuttack in ITA number. (213/CTK/2007) for the assessment year bracket AY 2004-5. While admitting this appeal, on 24th November 2009, the following questions were framed for consideration by this court. Just reproduce pages 12 and 13. This court has heard the submissions of Mr. Gautam Mukherjee, Learned Senior Counsel for the SSC, Mr. Chimanka, Learned Senior Departmental Representative, Senior Counsel for the department. The background facts are that SSC is a charitable society. Undertaking voluntary social service in Orissa. Are you registered? Not yet, right?
Registered, Manoj.
Under 12A? No.
Under 12A, yes, Manoj.
The petition, the SSC is registered under Section 12 capital A of the Income Tax Act, 1961 bracket Act, and is entitled to exemption under Section 11 thereof. Paragraph. On 31st October 2004, for the AY in question, the SSC filed a nil return. Full stop. The return was, however, picked up for scrutiny by the assessing officer bracket AO. Full stop. In the assessment order dated 30 November 2006, the AO determined the total income at rupees 32,980 by treating 50% of the expenses of rupees 64,65,972 on charitable activities in two projects, that is in the Bhubaneswar slums to an extent of 45,36,364 and Karanjia to the extent of rupees 29,608, on the ground that it was for administrative establishment expenses and not in fulfillment of the object of single quotes rural and tribal development. Unquote. After the Commissioner of Income Tax Appeals bracket CITA confirmed the said order, the SSC went before the ITAT with the aforementioned appeal. There was a cross appeal by the department as well. Both appeals have been disposed of by the ITAT by upholding the orders of the AO and the CITA. Correct. It is pointed out in the additional grounds filed in the present appeal that for all the subsequent AYs, that is 5, 6, 6, 7, and 7, 8.
7, 8, 8, 9, and 9, 10.
7, 8, 8, 9, 9, 10. The entire expenditure incurred by the SSC for its charitable activities, including rural and tribal development, have been allowed in full. Paragraph. Following the principle of consistency as explained with the Supreme Court in Ravata Swami Satsang versus CIT, begin with the citation. The court sees no reason why for the AY in question, that is AI 2004-5, the 50% of the expenses ought to have been disallowed. To stop, no satisfactory reasons have been provided either by the AO or the CITA or the ITAT for doing so. Consequently, the questions framed by this court are answered in the question number 1 is answered in the negative by holding that the disallowance of expenditure could not be made without rejecting the books of account. Question number 2 is answered in the negative by holding that the expenses for tribal people living in Bhubaneswar slums cannot be treated differently from the expenditure on the tribal areas in Karanjia. The other questions are again answered in favor of the SEC and against the department. In sum, by holding that there is no justification in disallowing rupees 2268,182 as claimed by the SEC towards its expenditure on charitable purposes. The impugned orders of the AO, CITA, and ITAT corresponding to the above questions are hereby set aside. The department will now give tax effect to the present judgment within 8 weeks. The appeal is disposed of.
Wiki list item number 39.
My lordship, after item number 40, my matter may kindly.
All right. 40.
Wiki list item 40.
I beg to appear for the SSC.
All right.
The Lordship has already admitted the question of law. Here, your Lordship has answered one question in favor of the revenue in ITN number 2014 dated 4/3/2022. Your Lordship remember that the Leon account depositing and Leon account.
Yes.
Electricity dues. Here the
No, Malad, I'm sorry. This is on the weather.
Yes, I know that what you are into something. Here the question is whether on the fact and circumstance of the case run internal phase 8 justified to holding that when the complete material not produced or nor were available with the assessing officer during the course of original assessment proceeding, the assessing officer cannot reopen the assessment under Section 147 of the Income Tax Act 1961, even as the income chargeable tax had escape assessment. And then another question, B, whether on the fact and circumstance the case and law, the learned traveler justified is not appreciating the fact that non-deduction tax under Section 95 of the IT Act had rendered the assessment under assessed, and whether subclass C of excellence 2 of Section 147 of the Act, thus as in penalty ignored by the learned traveler. Therefore, let's see this is relating to year 8-9. The reason for reopen of the assessment has been deferred.
No, the original assessment was under 143.3.
Yes.
So you examined all the books of account then?
Yes, but the fact remains is that not the.
Were there new materials to justify the formation of?
But it was not filed before the authority or not. The document was not available for the assessing authority at the time of assessment. It was not form any opinions so far as this issue is concerned.
No. What was the new material?
I understand that he has produced that document, but my submission would be not that he has not formed any opinion. If he has not formed any opinion, the question of change opinions, my submission not be arises.
No, not forming an opinion without noticing it is one thing, but after noticing it, he doesn't form an opinion. That's still an opinion only.
So my submission is not.
In fact, my lords, if I may be permitted, my lords.
Yes.
My lords, if my lords will see para 9 of the impugned order. My lords have para 9 of the impugned order.
Yes.
It starts with, it is further argued. My lords have that?
Yes.
It is further argued reassessments are initiated on a mere change of opinion. It is submitted that the AO within notice stated wherein various details, documents and information books of accounts were called for. Within notice dated so-and-so at point 7, the assessee was required to submit hard copy of annual TDS return together with details of deductives. Point 19, this note assessee was required to submit item-wise details, party-wise details of transmission charges along with TDS deducted, conversion charges along with TDS deducted, and on the same quarrying and raising expenses amounting to so-and-so on TDS deducted, and some factory expenses and export promotion expenses of so-and-so along with items held so-and-so. Then Maharaj would note, it was therefore contended all material information which was necessary for framing the assessment was disclosed. Details of import expenditure in foreign currency as per Schedule O of the audited accounts for the financial year 6-7. Therefore, it cannot be said opinion was formed by the AO during the course of original. The original assessment was passed under 143.3, and the AO has disallowed deduction for payments made to non-resident parties amounting to so-and-so under section 40AI for non-deduction of tax at source. Therefore, my lords, the submission before the tribunal was that I had made some foreign payments. Out of some part, the AO made a disallowance. Now, in the 148, he can't say that I didn't look at the balance details and therefore I'll make a disallowance of the balance details. That was the point on which the tribunal said, once you examine an issue and you make a part disallowance, it then amounts to a change of opinion.
Yes.
And my lords, the tribunal refers in para 11 to the decision of the full bench of Delhi High Court in Usha International and says that there may be circumstances where the issue is so obvious that without examination, it could not have passed muster. And the reason, my lords, the tribunal quoted this decision was that where the officer makes a disallowance out of a part of a larger subset, then he is bound to have applied his mind before disallowing a part of the subset.
Right.
And then, my lords, following Kelvinator, and then, my lords, even for the my lords, subsequent year, this was the finding in assessment year 8-9 as well, that, my lords, is recorded in para 14 of the tribunal's order. May I read para 14, my lords?
Yes, similarly.
Yes, it was submitted in the assessment year with a notice dated so-and-so. Assessee was required to make copy of the return, balance sheet, P&L, tax audit report, sorry, no, copy of original TDS certificates. Again, the assessee was submitted commission paid during the year, details of TDS, details of traveling and conveyance. In respect of 43B, my lords, in which, my lords, have on the merits held against me, my lords, I made complete disclosure in the accounts. Therefore, to say that some new fresh evidence has come to the notice is not correct. In fact, my lords, the reasons record, it says later on it is noticed so and so. It doesn't say any fresh tangible material has come to the notice.
So what about that section 195 non-deduction?
Yes, Malaj. Was the entire in the first year assessment year 7, Malaj are concerned today with assessment year 8-9. If Malaj will kindly see the reasons at para 16, which the tribunal has extracted.
Yes, please.
It starts with later on, it is noticed that the company has debited so and so in the P&L, but has paid electricity duty. Because this is disclosure made in my return and in my audited accounts.
Correct.
And then the next is, my lords, what the officer says is each time you make a remittance to a non-resident, the second part on of the, let's be point number 2 below the 43B issue, is
Same
that each
materials,
time you
again,
make a
same thing.
payment to a non-resident, you must withhold tax. Well, that is now contrary to the Honorable Supreme Court in GITC, my lords, 327 ITR 456.
Right.
Well, that's my respectful submission.
That the region, space 15, the same region, because the amount was debited, it was not specifically not considered by the original assessment order. Therefore, my submission would be not, it does not form any opinion so far as this this amount is concerned. Therefore, cannot be said to be a change of opinion.
All right.
And this issue has already been considered by Lordship on ITO number 2014 dated 4/3/2022 in favor of the revenue.
The present appeal by the revenue is directed against an order dated 25th October 2017 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, in ITA numbers 47/CTK/2014 and 73/CTK/2014 for the assessment year bracket AY 2007-08.
So this is led 8/9. This is led to 8/9 assessment year.
No, come to.
This appeal is directed only against the order for AY 8/9. It was disposed of together, but the revenues only come up in 8/9.
Because in that caption, then you have wrongly typed it then. Okay. Then ITA numbers 48 and 74/CTK/2014 for assessment year bracket AY 2008-09. While admitting this appeal on February 2020, the following questions of law are framed for consideration. Take from page 8, A and B. A perusal of the impugned order of the ITAT, reveals that in the original assessment proceedings, the SSC had produced various documents, books of accounts, on the basis of which the assessment order was passed by the assessing officer, bracket AO. As noted in para 14, the SSC submitted copies of the audited balance sheet, the e-return, details of the commission paid, the TDS details, traveling and conveyance commission under the head selling expenses. We'll stop. Further, in respect of disallowance under section 438 of the Act, the SSC had made a disclosure in schedules I and N
43B.
at point number 4.
It should be 43B. It won't.
Yeah, sorry, 443B of the Act. Sorry. This persuaded the ITAT to observe in para 17 that the recorded reasons for reopening the assessment made no reference to open quotation any fresh tangible information, unquote, which came to the notice of the AO after completion of the original assessment under section 143 bracket 3 on 29/12/2010 for the AY 2008-09. A reference was made to the decision of the Supreme Court of India in CIT versus Kelvinator of India Limited, 320 ITR 561 bracket SC. So it is accordingly concluded that full stop. Even as regards the second question, regarding section 195 bracket 1 and comma 2, I mean bracket 2 and bracket 3 of the Act, there were no fresh materials to enable the AO to form a subjective satisfaction regarding income having escaped assessment. Paragraph. Having heard and counsel for the parties and having carefully perused the impugned orders, the court is satisfied that questions framed have to be answered in the affirmative, that is in favor of the assessment against the department. Indeed, there appears to have been no fresh material on the basis of which the AO could have formed reason to believe that income had escaped assessment. The appeal is accordingly dismissed. No resist was.
I'm grateful, Malaj.
Weekly list item 39.
You can stop the stream, live stream.
Yes.